Good morning, everybody. First request to you all, please put your phones on silent. You don't want to close that, that's okay. We already have with us eminent people, Professor Akash Gupta and my dear Ashish Mohan. Both of them are outstanding. So we should use them. I'm not taking that time. We are taking this initiative to see how we can reach out to these youngsters. Even my youngsters who are bouncing at the door of the bar. There are so many intricacies that come in our legislature. And one finds that when even one is arguing or the judge is delivering a judgment, he misses the point. The purpose is to fine-tune that with these experts. The purpose is that you must be able to come back to them and ask them clarification, questions. And on the lighter vein, I want to tell you something. That's why I came. It was not my time to come in. But I had a teacher in my law school who used to teach me Trademark Act. Those of you who are familiar with Delhi University, we used to get second case law. We used to read them, grasp them, and then have discussion. I had not gone to a class president of law. I missed that class and I met him in the dean's room. And he told the dean, please don't speak to him, he did not attend my last. So I promised him I'll do it next time. So next class I took the brief, I took those judgments, read through it, made my queries. Then I don't know how it struck me, but I thought there could be some change in the law. So I went to Guwahati, that was the only place near university, where there was a university, some bookseller or something, where I went to buy the act. I read the act, and here comes, there was some amendment. So I went to the class, sat right in the front, and after he discussed everything, I stood up and I said, so I said, please, I want to read with you section. So I read section here. I didn't tell him there's an amendment, of course. So he was not prepared for it. He said, okay, we'll discuss again in the next class. So that we ended. At once, up lunchtime, he sent for me and called me to his room, get me small cubicles where professors and teachers. And he told me, if you come to my class now, that's my tongue is so you should be ready to put such questions which will help all participants understand something that they all would have missed it, even during their deliberation. But could be possible. Or there could be a view that you can take distinct from the view which established. And I'm totally against this part, I must confess that what we do, we get a case, we go to that, I was yesterday told, there's now a research platform also. I don't know it. You go to SSC, you go to Manupatra, and start looking for a case law. Without reading this judgment, without knowing what is in this judgment. So judgment will be in the context of the facts of that case. It can't be. The same provision of law can be interpreted three times. Different situations. So please be prepared, be vigilant. And the opening remarks have been made by none else but J.P. Singh, President-elect of Maadhyam, an outstanding lawyer. If you have any interest, I will give my own session, who is from my chamber. I start shivering. President J.P. has come now and doing the first session. Now, these are things that you must grasp. My purpose is only to request. Pay your attention to it. It is important. Because when you pay attention, I'm sure you have got the Clear Acts in your kit. You can read your whereas, read what the honorable professor or my dear friend is giving you, and then put it across. And you will read that in the context of what JP is going to make in opening remarks. May I request JP Singh, President-elect, to make an opening remarks. Please, sir. Good morning, everyone. See, when you are in presence of some, you forget your prepared speech. Also, howsoever I may prepare when I appear in court, I know that I'm going to go off somewhere else. And so the start that he made about the judgment being wrong. There's a book written by Justice Rohinton Nariman where he's talked about dissenting judgments, which ultimately became law. So the court can go wrong. See, and so therefore the law is evolving every day, it changes, and therefore there is nothing which is perfect. Statutes change. We will be talking about the amendments to the Arbitration Act which have come. And in keeping with pace with the time, these amendments, after the judgments are delivered by the Supreme Court and various courts, so they are trying to keep up pace with those judgments. So, let me first tell you something about Maadhyam's journey. We began as primarily for purposes of, as you see the name, conflict resolution. And the first thing that comes to your mind is mediation. In our country, the mediation started as a court-annexed experiment. And so the result was that courts wanted, the dockets are overflowing. So court wanted some of their matters being knocked off their roster, and therefore they started pushing for settlements. While purpose of mediation is not settlement, but conflict resolution. Reaching the conflict and trying to find a resolution for that conflict. And that's where the idea of Maadhyam grew. Something as a private institution outside court. And today, the journey has been a long journey. We have had various people who joined us in the beginning. We lost them in that journey, who are founder members. We had Ranjan Bhai, who was, we called him Bhishma Pitama of mediation. He didn't like that term though. And we lost Sadhna. Today you see we are doing this 5th episode of the ADR series in our memory, So when I talk about arbitration, you see arbitration also is a method of, since the court's docket, as I said, were overflowing, so alternative dispute resolution. First method that was looked at was arbitration. Civil Procedure Court had provision for arbitration. The 1940 Act came, and that provision was deleted. After nearly 1940 and 84, 44 years down the line, the Supreme Court lamented the way every arbitration award lands up in court and is challenged. It makes the legislature weep and the lawyers laugh because it was lining their pockets. Then 1996 Act came, and 1996 Act has also seen several amendments. Ours is the 5th episode. We have dealt with several aspects of arbitration in our earlier 4 episodes. We will be dealing with seat and venue even today. There is no clarity on where the seat and venue would be. Enforcement. What is the power of the court under Section 34?
amendments again to 34. So all that, of course, the experts will lead you through them. And though the court's approach has been hands-off, and if you see today's topic, it deals with the jurisdiction of the court under 34. That's one of the things that you'll be looking at. And the interesting part is, again, I mean, you know, when these topics were made, they have made me run from pillar to post, looking for where is that Delhi High Court judgment which set aside a commercial, international commercial arbitration, and I'm still looking. So I'm sure the panelists here, the professors here, and you'll see the combination that we have today. One is to give you the educational aspect, the theoretical aspect by the professors here, and you have senior advocates who will give you the practical aspect of how that particular section again is construed in court. Right, so you'll have both the, the advantage of hearing both of them. So instead of getting between them and you, I think I should call upon them to start. So in the order that them before we call upon them.
Good morning, everyone, and a very happy New Year to you. Although you have been provided booklets with the resumes of all eminent speakers today, but I'll just give a brief introduction of our first speaker of the day, which is Professor Akash Gupta. Professor Akash Gupta is an accomplished legal scholar and an ADR expert. He has been with us in earlier episodes as well. Professor Gupta is an assistant professor and assistant director of Center for Alternate Dispute Resolution at Jindal Global Law School and a visiting faculty at the National Law School of India, University, Bangalore. Beyond his academia, he is an expert judge in moot court competitions. He has conducted workshops at over 50 law schools across India, and he is a known scholar even outside India. He joined Jindal Global Law School in 2019 and has contributed significantly through editorial and advisory roles in leading arbitration and law journals. Along with Professor Gupta, we have Senior Advocate Ashish Mohan. Mr. Ashish Mohan, Senior Advocate, has a distinguished career embodying excellence in constitutional law, arbitration, taxation, and commercial litigation. With over 2 decades of legal practice, Mr. Mohan has levered his razor-sharp legal acumen, strategic prowess, and unwavering commitment to justice. Beyond his legal practice, Mr. Mohan is recognized globally for his exceptional contributions. He has been ranked as Band 1 lawyer by Chambers Asia Pacific, an elite practitioner by Asia Law Profiles, and litigation star by Benchmark Litigation Asia Pacific. These accolades are a testament to his influential role in shaping the legal landscape. His illustrious career is a source of inspiration to the legal fraternity. I'll hand over to Professor Akash Gupta to start the session.
One and all present here. Thank you very much, ma'am, for the introduction. Thank you very much, sir. And thank you to Maadhyam for having me again at this session. So in the next 30 minutes, this is what I'm going to discuss. We are going to discuss section 34.2a, 34.2b, its distinction between the power of the courts. So let's start with what J.P. Singh sir said in the opening remarks, that the Indian courts are having a backlog of cases. I was searching the number of cases pending while traveling from Sonipat to here. So it's 4.5 CR plus total number of cases, 1.1 civil cases which are pending. So there's a reason why we are moving towards alternative dispute resolution instead of having the traditional method of dispute resolution, which is litigation. And with this, we know that whichever field you go, it doesn't matter whether you go for matrimonial disputes, you go for civil disputes, no matter which field you choose, but ADR will be there for you. And therefore, now let's start with episode 5 of Sadhana Ramchandran ADR learning series. So are we ready? Yes. Okay. Now, the roadmap for this session is this, that first we'll be starting with section 34, the legislative framework. Then we'll be dealing with the distinction in between the powers of the courts and the jurisdictional issues, who has the burden of proof, all of this. Then when courts can interfere under section 34, whether that also gives you a power to modify the award, and at the end we'll be looking at the recent changes which has been proposed by the draft arbitration and conciliation bill with respect to section 34. Now let's start with this meme. I know it's a Saturday morning, so let's start with this. What's the beginning of the problem in arbitration? The beginning is not with respect to arbitration agreement. The beginning of the problem is once you have an arbitral award. As a layman, when you enter into an arbitration agreement, you think the moment you have an arbitral award, the problem is solved, isn't it? That A has to pay money to B, which is ordered by the arbitrator C, right? However, the losing party has this, that let's use section 34 and get the award set aside. What do we mean by setting aside? Annulment, challenge of the arbitral award. It's very simple. Let's say that this is the arbitral award which has been provided by the arbitral tribunal, which provides that A has to pay this much amount to B. Once you go to court under section 34, the court decides setting aside application and it's successful, which means this does not have any force of law. Then what do you do with this? If you go with this to the enforcement authorities, will they enforce it? The answer is no. But the arbitrator always say that our award jhukega. But who decides that? It's not the arbitrator who decides the fate of the arbitral award. Who decides it? Of course, the decision making, the rights and obligation is being decided by the arbitrator. But section 34, the power to look into these applications rests with the courts, right? So it's the courts which decide it. Now let's go to the second part of this. If we say that we have section 34, which provides for setting aside application, do you think arbitral awards are final and binding? What do you think? Anyone? Our arbitral awards, once, let's say this is our arbitral tribunal, they decide that Akash has to pay 10 lakhs rupees to ma'am. Ma'am, what's your name? So it's Akash versus Abha. Akash has to pay 10 lakhs according to the arbitral tribunal. This is the arbitral tribunal. Is it final and binding?
Yes, section 35 says that.
Yes, section 35 provides for finality of the arbitral award. Please understand this. Just because we have section 34 procedure where a losing party can make an application, that doesn't mean that the award is not final and binding. Section 34 is a provision where a losing party may make an application, which is not mandatory. But of course, when you lose a case, you have all the rights to move towards section 34 and file a section 34 application. But is it mandatory for the courts to set aside the award? Or is it a discretion which they have to look into? Whether they have to apply their judicial mind and then decide. So finality is still there, section 35, but of course it is subject to section 34. Now the idea of this meme is, if you have watched Squid Games, so it's more like, you know, the life of this person is all saved by the other person who is hanging him with the, you know, his jacket. Now the idea of this is the courts have to make sure that they do a balance in between making sure that the award is intact unless until section 34 grounds, which are the limited grounds, has been triggered. So of course, if let's say the arbitrators did not follow the procedure which is agreed by the parties, in that case, yes, the courts can set aside the award. But let's say if I say that this arbitral tribunal has taken an interpretation B, however, there exists another interpretation which is interpretation A. I like interpretation A, but they chose interpretation B. Can I challenge the award? Based on this, that the arbitral tribunal did not choose the right interpretation. The answer is no, right? Now this is the idea of section 34, that you cannot create an additional ground, section 34. Now this is an award creditor. The winning party in an arbitration, thinking about enforcement, if you have watched Pushpa, you'll connect to this theme, that every time this police official will be thinking of how to take revenge from Pushpa, and there is a whole queue. Now award creditor always think that the moment you have an arbitral award, you'll get it enforced. But there is something in the middle, in between the arbitral award and the enforcement, which is your section 34 challenge procedure. And challenge becomes more complicated when you have an international commercial arbitration seated outside India. The whole issue what sir was pointing out to, the idea of seat and venue, unless until you are clear with that. There was a scenario in India before 2012, before Balco, that Indian courts were setting aside judgments using section 34 under part 1 when the seat was outside India. So this is the problem with the enforcement, because for enforcement you have to first look at section 34 application if it is fair. So now let's start with section 34. Section 34 first starts with this: recourse to court can be made only through an application under section 34(2) and section 34(3). Now 2 reads, an arbitral award may be set aside by the court only if the party making the application establishes on the basis of the record of the arbitral tribunal that. What do we mean by this, party making the application? Which party is that? Is that the award creditor or is that the award debtor? So the person who, in this example of Akash versus Abha, I have to pay 10 lakhs to ma'am. Who has lost this case? Me, right? So I have to pay. So the losing party is called award debtor. Okay? Ma'am is the award creditor. If ma'am has to get money, why she will go to court and file section 34, right? So it's the award debtor who has to make an application to the court. So who has the burden of the proof here? If I am moving to the court, of course I have the burden of proof. I have to showcase. Ma'am doesn't have to showcase anything. I have to prove that one of those grounds under the section 2A is triggered. Now what are those grounds? Incapacity of a party, which means if the party was not even having the capacity to enter into the contract, however the whole arbitration took place, I can get it set aside. Second is invalidity of the arbitration agreement. The arbitration agreement was itself invalid. Which law do we look at? For that, it's the law governing arbitration agreement. Third is improper notice or inability to present the case. Now, let's say that the due notice was not served to one of the parties and there was an ex parte giving one opportunity of being heard. Later on, can that party who has to pay money in this ex parte proceeding can come under section 34? The answer is yes, because one opportunity doesn't mean anything. Okay? So you have to give an ample opportunity, a reasonable opportunity of being heard. Fourth one is award exceeding the scope of arbitration. Let's say that the scope of arbitration was ABC issues. However, the arbitral tribunal decided on ABC and XYZ issues. So there are 6 issues, but only 3 of them were a part of the arbitration agreement and the scope. Now that will be an excess of mandate case with respect to XYZ. But the award will be valid with respect to the first 3 issues, which is A, B, and C. The fifth one is tribunal composition or procedure not as per agreement of the law. Let's say it is provided that you have to conduct the arbitration under the aegis of Maadhyam and Maadhyam rules will be applicable. However, you go to, let's say, IAMC Hyderabad and you conduct it and the arbitrator has given an award. Then you can say that the procedure agreed was the Maadhyam rules and not the IAMC rules. So the whole arbitration was not valid, and then you can trigger this fifth point under 2A. Now, the 2B, this is important, the court finds that. Here, is it required that a party proves that the subject matter is arbitrable, non-arbitrable, or whether it is in conflict with public policy, or is it the court which can independently do an examination? What do you think? 34(2)A provides that the party has to make an application, which is the award. Now 34.2b provides the court finds that subject matter not arbitrable under Indian law. Second, public policy violation. So whether a party has to make an application here, or can the courts independently also look into it? What do you think? Party can of course make an application, but is it also the court which can look into it?
Yes.
Please understand this. It's a very thin line of reference here. In the 34.2a, a court cannot independently investigate into it, that whether any of those 5 grounds are triggered. But in the B part, of course a party can, let's say if I have lost the arbitration, sir says that I have to pay 10 lakhs. Of course I can also argue it. But let's say I don't argue any of these. I argue that proper procedure was not followed. Whether in that scenario, the court can also say that this can be against public policy or this subject matter is non-arbitrable. The court finds that, so this provides a difference in between 34.2a and b. In b, the court can also look into this. Why? Because if the court provides for a challenge decision or an enforcement decision which is against public policy of India, that will not be the correct interpretation. So the court can independently also look into this. Now, this is a scenario which actually showcases you to understand section 34 looks very easy, that it's these grounds. But majority of the cases also come upon the merits of the dispute, the substantive merits, the substantive interpretation, modification. So anyone who has to decide section 34 application starting from the lower courts till the Supreme Court, it's actually very problematic to decide section 34 application. So this is a scenario which showcases that. Now, public policy in India, first it was very wide. There were multiple judgments which provided for wider interpretations. However, later on it was narrowed down, and some of the examples which are given under explanation 1 is induced by fraud, corruption or violation of confidentiality. Second, contravenes the fundamental policy of Indian law. Third, conflicts with basic morality or justice. Explanation 2 provides that whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. The caveat here is when you look into the violation of fundamental policy of Indian law, that shall not be a review on the merits of the case. Can the courts review the merits under section 34? Saying that the arbitrators did not appreciate XYZ evidence. No. Or their interpretation, out of 3 interpretations, they should have taken second route instead of first. Can they do that? No. Are you sure they can't do that? I'll give you another example for this. Let's say the arbitrators say that A has to pay to B 10 lakhs. Can the court say that B has to pay 10 lakhs or 5 lakhs or whatever to A? So let's say it's a 3-member arbitral tribunal. 2:1 is the decision. Can the courts say that the minority award is going to be the final award? What do you think? Let's keep this in mind and move forward. I'll answer this by the end of the class. Okay. Now, if we look at the powers of the courts, the difference. 34.2a, we talked about this, that the party initiates it. The party can also initiate it in the 34.2b, but the courts can also initiate that. Grounds of review, it's procedural grounds which are mentioned within 34.2a. In 34.2b, there are only 2 grounds, public policy violation and arbitrability. Arbitrability is fairly simple. If you arbitrate a sexual harassment matter in India, whether that's arbitrable or not, whether that is allowed to be arbitrated or not, husband and wife dispute, whether it's arbitrable or not, or let's say a competition law matter. So some of these disputes are already arbitrable outside India. However, within India, if you ask me that whether consumer arbitration is allowed, the answer is no, because of a Supreme Court judgment. And the Indian courts have not provided a particular section on arbitrability. If we look at some of the laws like Hong Kong Arbitration Ordinance, they clearly provide a list of subject matters which are suitable for arbitration. But if we look at India, the landmark judgment is Vidya Claudia and Booz Allen, which is still applicable. The burden of proof, we have already discussed this, that it's on the parties in 34.2a. 34.2b, if the court is independently looking into it, there is no burden of proof on the parties, but of course if I am the award debtor, I will of course try to prove that this subject matter is non-arbitrable and this violates the public policy. Now this is public policy under section 34, because if you find section 34 application, majority of the cases you will not find the first 5 within 34 to 8. You will find public policy violation. There have been many cases, if you go to SEC online or Manupatra, the moment you go to section 34 to B2, which is public policy, majority of the cases will be this, and there have been judgments where the courts also went to an extent where they actually reviewed on the merits. But finally, after the explanations came in, as JP Singh sir was pointing out towards the arbitration amendments, now the law has been more structured, more clarified, that public policy does not entail a review on the merits of the disputes. In DDA, this is the old perspective of section 34 and interference. This is not the current law. So the principles for interference with an arbitral award under section 34(2) of the 1996 Act was observed as this, that an award which is contrary to substantive provisions of law, the provisions of Arbitration Act 1996. You'll get my slides. You don't have to write down notes if you don't want to, or click pictures. If you can't get it, you can just ask me. I'll give you the slides. It's already on open source, so you'll get the slides. The second is the provisions of the Arbitration Act. Third, against the terms of the respective contract, patently illegal, prejudicial to the rights of the party, is open to interference by the courts under section 34. Now, this para 21 provides for a very wider interpretation of what exactly is the scenario where you can interfere with the award. However, if you look at the recent set of judgments, for instance, MMTC 2019 judgment, the court observed in exercise of jurisdiction under section 34, the court does not sit as an appellate body over the arbitral award and may interfere on merits only on the well-settled limited grounds where it is patently illegal, whether it shocks the conscience of the court. So they have limited the powers and they said that we are not sitting in the court as an appellate body. Can you appeal an arbitral award to the court?
Section 37.
So in section 37, you appeal the arbitral award to the court. So in this scenario, let's use the same scenario, that the arbitral tribunal renders an arbitral award. Can I take that arbitral award, that piece of paper, and go to the courts and appeal? Section 37, isn't it? Is it an appeal? Exactly. Please understand this. Section 34 uses the term challenge. Once you have an order of a court, let's say I take this arbitral award, I go to a lower court here in Delhi, and they decide that this is unsuccessful. I can go to a higher court in appeal under section 37. That is an appeal to an order of the court related to an arbitration. But that is not an appeal of the award. That is an appeal with respect to the court order. So you can never appeal the arbitral award, you can always challenge the arbitral award. There is a difference because appeal is very wide. Challenge is narrower. In another 2024 case, OPG Power, it was observed that mere violation of law is not enough to interfere with an award, but it must conflict with the most fundamental aspects of public policy, that is justice. Now the question is, if there is a mere violation of law, does that constitute a violation of public policy? The answer is no. It has to be a fundamental policy which has to be violated. Similar case in 2024, another Supreme Court judgment where they said that interference has to be confined to the grounds which are mentioned, the 5 grounds under 34(2)(a) and the 2 grounds which are mentioned in 34(2)(b) plus the patent illegality which is mentioned under 2(a). Now, when a counsel has been asked by the client that when it's going to be enforced, the counsel doesn't know exactly because there is a challenge procedure which is given under section 34. Then the challenge can be appealed to the higher court. Finally, you can go up to the Supreme Court. So the counsel may say something like this, मतलब ऐसा बिल्कुल अब immediate नहीं सोचें, but सोचेंगे. So you exactly don't know as a counsel also that when it will be enforced, because you can go till the Supreme Court taking the section 34 application. Talking about the modification of the award, there have been two different perspectives. One perspective is NHAI versus Haki, where they said there is no power to modify the award. Modification is this: 2:1 is the arbitral tribunal decision, whether the courts can say that the minority award is going to be the final award. That is something what we call modification. It can be even a smaller modification, but this is the best example which comes from Sangyong Engineering Construction versus NHAI, where modification was done and the minority award was upheld using the route of Article 142 of the Constitution to do complete justice. So there are two views, and therefore there is a constitutional bench which is pending with the Supreme Court on this, that whether modification is allowed under Section 34 framework or not. That is Gayatri Balaswamy. Now, the question is whether it should be allowed, modification of arbitral award, because you are going to relook into the decision making of the arbitrators. So, if you ask me, my personal take is, if you have to modify, if you have to do this by the court, you have to provide the powers within the legislative framework. For instance, the English Arbitration Act already provides for this, but the threshold for modification is a very high threshold. So if you have to use that power, you have to provide that within the Act, because otherwise, if you look at Section 5, Section 5 provides that minimum judicial intervention principle. Unless until the Act provides that you have the power, you cannot interfere with the award. So Section 5 read with Section 34. Whether we have the power of modification, the answer is no. So if you have to modify it, you have to get an amendment like the English Arbitration Act. And I have a quiz, so I stop here, and you have to go to kahoot.it. You have to use your mobile phones. This is how you play. Some of you who were there in the previous session.
Akash, I have a question for you.
Yes.
After you finish it, put your question.
Okay. Later on.
Okay, so this is how you play the quiz. You have to go to Kahoot, K-A-H-O-O-T. I'll share the pin which is going to be right here. And the questions will be displayed over the screen. And the options will be right here. You'll get 4 options or 2 options, color options. You just have to tap on your mobile devices. So you just have to make a group, which is like one row, it's going to be one group. So only one person has to tap the answers. I'll just show you the OTP. It's K-A-H-O-O-T. They'll be asking you for a game pin. I'll show you the game pin. And you get 30 seconds to answer this. The faster you answer, the more points you get. So it's Kahoot, K-A-H-O-O-T. So this is the game pin which you have to enter at the beginning. So once you put the game pin, they'll ask you for a nickname. You can use your name and enter. Okay, so let's start. You have to join as a. Okay, so let's start with this. The question is on your screen. The options will be here. You just have to tap the color options. Okay, unless until you get 70% of the answers right, you don't get a certificate of this. So it's more like Squid Games now. Either you get 70% or no certificate. No, I'm just kidding. You think it's a mandatory provision, section 34, that you have to set aside the award if a party files, or there is a discretion involved of the Okay, 34 is the appellate arbitrary tribunal, which is introduced, which provides that you have to choose in between the arbitrary tribunal or the courts to look into section 34, which I missed. So there is an option. Okay, in short, this draft bill provides that you can choose your own appellate arbitrary tribunal to have section 34 applications to be heard by this special tribunals. So it can be a private appellate tribunals, you can choose IAMC, Maadhyam appellate tribunals to do that. But once you choose the appellate tribunals, the courts will not have the power under section 34. Now this is something which is already happening in some parts of the world like Poland, but not majority of the countries agree with this. Second thing is that this is more like an annulment tribunal, which is called under ICSID. But here in the Indian bill uses the name appellate arbitrary tribunal. Once you choose that, there will be no powers of the court to interfere with section 34 because that power will be delegated to a private arbitrary tribunal. But this is just a draft bill. It's not inserted within the act. It's not there in the act now. If the arbitrary tribunal decides on an issue not submitted to it, this may lead to. Is that a full setting aside, partial setting aside, or it will be enforced, or whether you have to constitute a new arbitrary tribunal? You cannot set aside the whole award. Some portions of it will be valid. Only the partial award will be set aside. Scope of review by the court under 34(2)(a) is limited to procedural and jurisdictional errors, broad enough to look into the merits or public policy grounds or re-examine the evidence. What are the powers? Advocate R.
Thank you. This should be better. So I'll try not to repeat anything that's already been said and dive straight into the distinction between 34 2A and 2B of the Act, so that we deal with the difference in the challenges. There is a substantial difference between the two. So far as 34 2A is concerned, if you all have your WARE Acts in place, you will find that all the grounds mentioned in 34 2A are really procedural grounds of review. Procedural in the sense that the court will only see whether the procedural bond is correct. Secondly, whether expressly can be found that the award has to be set aside due to a defect in procedure again adopted by the tribunal. It does not entail a review on the merits of the matter. You will find 34 2A, firstly, one slight distinction so far as my friend is concerned. An issue came up as to whether the court can so motu set aside an award. Now, firstly, that can't be. Whether under 34 2A or 34 2B. Because 34 1 says, for setting aside an award, an application is required by a party. So it's not like a 226 or 227 of the Constitution where the court may exercise so motu review of an administrative decision and set aside that decision. So that can't be done. What 34 2A really requires is that the party making the application establishes on the basis of the tribunal's record that A, the party was under some incapacity. Now that incapacity, the word incapacity, really results in failure of a party to present its case before the tribunal. For example, a party was not served notice of the tribunal's proceedings, or the party concerned did not know that the tribunal had already been constituted, entered upon the reference and started its proceedings. Now similarly, a party may be under a different kind of incapacity, and that incapacity may well be unsoundness of mind. For example, just prior to institution of arbitration proceeding, a person is diagnosed with a mental illness. He is the respondent in the arbitration proceeding and cannot participate in the proceeding. That mental incapacity will constitute an incapacity for the purposes of 34 of the Act. Similarly, a person may be a minor. A person who is a minor may have entered into a contract. The other party may not know. Supposing a 16-year-old enters into a contract, the other party may not even know anymore. But that minor can nevertheless take the ground. Look, I was under an incapacity when the arbitration proceeding started when I was 16 and a half. I was a minor. I was not represented by a guardian. Consequently, in view of that incapacity, this award is to be. The court may take a view on that. That's a possibility. The next ground that you will find under 34 2A is that the arbitration agreement itself is invalid. Now, what does this mean? The arbitration agreement in law is a separate agreement from the main contract. The law is settled on that. Whether it constitutes an arbitration clause or a separate arbitration agreement contained in a different contract makes no difference. The arbitration agreement will be treated as a separate agreement. So under 34 2A2, the court is not going to consider whether the merits of the agreement, the main agreement, is invalid. For example, the main agreement may be an agreement which is illegal in law, but the arbitration clause may still be valid. Because the arbitrator will then have to decide as to whether the merits of the agreement are invalid or not. The arbitration agreement is limited to the arbitrator, the parties agreeing to submit their disputes to arbitration, that's all. It does not entail merits again. Now, when could an arbitration agreement be invalid? One example of such an arbitration agreement would be, for example, the arbitration agreement itself was under coercion.
or under a fraud or a mistake or fact by both the parties. The grounds remain the same as are specified under the Indian Contract Act. An arbitration agreement is just like any other thing. The only distinction being it is a matter of procedure as against a matter of substance. Usually you will find contracts are a matter of substance, dealings between parties. An arbitration agreement is a procedural contract and only specifying that, look, instead of going to court, we will go to arbitration trial. That's all. Now, you will find under section 27 of the Contract Act, usually an agreement which is in restraint of legal proceedings is deemed to be invalid. It's a wide agreement. An exception is carved out for an arbitration agreement under 27, saying that if parties have agreed to submit to arbitration, that agreement will not be treated as an agreement in restraint of legal proceedings. Legislature has been conscious of this right from the very beginning. So the 1996 Act, of course, had preceding acts. So therefore, while dealing with these clauses, that the arbitration agreement is invalid in law, you will again have to go back to the Contract Act to see whether the consent was free or not. Section 10 of the Contract Act. Similarly, you will have to go back to section 13 to 25 of the Contract Act. Of course, wide and voidable agreements are dealt with by section 13 all the way till section 30 of the Contract Act. But you will find that section 26, 27, 28, 29, 30 really are not applicable to arbitration agreements. They can't apply. For example, 26 is an agreement in restraint of a married marriage, or 27 is in restraint of legal proceedings, etc. Or 28 being in restraint of trade. Now, an arbitration agreement cannot possibly fall within any of these categories. It can only fall within the categories specified in sections 13 to 25, which provides for, of course, coercion, fraud, mistake of fact, and so on and so forth. Section 23, for example, is that the arbitration agreement, the purpose of the arbitration agreement will be unlawful. For example, to bypass a second valid contract, two parties enter into an arbitration agreement, enter into a separate arbitration agreement to bypass a third party's rights. That agreement may be considered to be invalid for the simple reason that you are trying to bypass somebody else's rights. The agreement may well be treated as a fraud, and consequently it will be invalidated under 34. It is a possibility. So far as number 4 is concerned, it talks about disputes not contemplated by the arbitration agreement or where parties have not submitted a dispute to arbitration. Now this you will find very often in government contracts. In large government contracts you will find that there are clauses which provide for accepted matters. So the contract will say that on X, Y and Z issue, parties will go for arbitration. But on A, B and C, the decision of the engineer in charge or the contractor, etc. will be deemed final. Now, of course, that does not attain finality as such, because if you were to read it as saying that one of the parties deciding a matter attains finality, that would then fall within an agreement in restraint of legal proceedings. So the courts have interpreted that to say that on those ABC issues where the contract says that it is final, you will have to necessarily go to a civil court instead of for arbitration, because arbitration is a creature of contract. So if parties have agreed not to submit those disputes to arbitration, you can't go for arbitration. You can go to arbitration only for those disputes where both parties have agreed that we will submit disputes to arbitration. Of course, this has been subject matter of a lot of litigation over the years, because effectively what happens is where the contractor or one of the parties says that, look, I have 5 disputes, 2 fall within accepted matter, 3 fall within the arbitration clause. Then what do I do? Necessarily the facts will remain the same. Very often. You can have conflicting decisions, one by the court, one by an arbitrator. What will you do? The court said that, look, eventually you can't sever these disputes, so therefore the arbitration clause really becomes a nullity. Go to the civil court. Club volume dispute. That's a possibility. And the last is, of course, that the composition of the tribunal is not in terms of the agreement between the parties or not in accordance with law. With this part means, of course, the Arbitration Conciliation Act. There is nothing under any other law that I know of which provides for an arbitration agreement, the composition of a tribunal being invalid. The only provision that I find in law is Section 10 of the Arbitration Conciliation Act itself, which says that you can't have an even number of arbitrations. For example, if an arbitration clause between the parties provides that you will have 2 arbitrators. 2 arbitrators enter upon a reference and then pass it on. It may be together, it doesn't matter. The fact is the composition is contrary to part 1 of the arbitration principle. Therefore, the challenge will lie in the 34. There is one other aspect of the matter that I'll stress on. So far as 34.2a is concerned, you will find that the language of the opening part of 34.2a is entirely different from 34.2b. It says, an award may be set aside by the court only. The party making the application establishes on the basis of the record of the arbitral tribunal. There was an amendment in the year 2019 which added the language on the basis of the record of the arbitral tribunal. Previously the law was that, look, I am a party, I wish to challenge under 34.2a. I don't necessarily have to go to the record of the tribunal to establish any of these grounds. I can need additional evidence before the 34th court. And there is a judgment of the Delhi Court, in fact, recent judgment of 2024 in National Agriculture Cooperative Marketing Federation of India. I don't have slides, I'm sorry. I prefer notes. What I can do is I'm happy to share my notes to whoever is interested. The judgment specifically talks about an amendment which came on the 30th of August 2019. Prior to 30th of August 2019, it was open to a party to read any sort of additional evidence, any sort of additional documents to show that, sir, my case falls within any of these grounds under 34.2a. Now, why is this relevant? This is relevant because you can find in clauses 1, for example, incapacity, or 3, party making the application will not give notice of appointment. Previously, you could leave additional evidence to show that, sir, on the date that the arbitration proceedings started, I was of unsound mind, here are my medical records. Those may not form part of the record of the trial. Now, according to me, this amendment is troublesome. It's troublesome because 34.2a, at least in part, contemplates grounds where a party could not participate in arbitration proceedings. 1 and 3 both talk about 1, incapacity, 3, inability to participate because I did not get due notice of constitution of the trial. Now, these facts may not be available on the tribunal's record. It may be impossible for me to prove it from the tribunal's record, although I can prove it from outside. Prior to 2019, technically I could produce that additional evidence. I could even produce oral evidence. I could produce a doctor to give testimony on affidavit or other to show that, yes, we were the I was treating her that way. But where do I get those facts from the record of the tribunal? It's impossible. Because that will contemplate that I, as a person of unsound mind, would have informed the tribunal that I'm a unsound mind. Putting the cart before the horse. Pretty hard to it. Therefore, this amendment, according to me, perhaps might need a review. It may be relevant so far as the arbitration agreement not being valid under law, for example. So therefore, what that contemplates is a party before the tribunal itself that raised the ground that, sir, I was coerced into entering into this agreement, or somebody defrauded me and therefore I entered into this agreement. So therefore, I took the ground before the tribunal. You can find it in the record of the tribunal that I have taken this ground. And therefore, under 34.2a, I can raise this ground. But unfortunately, that cannot happen when I am under an incapacity or where I was not served with notice. Now, for example, service of notice. The tribunal, if you see the tribunal's record, there may be a postal receipt saying that yes, notice was served. Or you might find an email saying that notice was served electronically. But I might have to produce additional evidence to show that my email account was closed down by the server. Or for that matter, my premises was possibly sealed by the MC. There could be various circumstances which I cannot establish from the tribunal. So this aspect will perhaps require a relook at some stage. The second aspect under 34.2a is that it places the onus squarely on a party to prove these facts. Supposing, now why is that relevant? You would just read the language of 34.2a. Party making the application establishes on the basis of the record. So therefore, the party must establish. Now, juxtapose this against the language of 34.2b, which says that the court finds. This distinction has in fact been dealt with by the Honorable Supreme Court in one nondescript judgment, which is hardly ever cited. But I'll read it. Why is this relevant? This is relevant because for 34 to apply, the party must necessarily have taken the ground. If a party, despite being under incapacity, etc., fails to take the ground, he cannot later tell the court that, look, please set aside the award, although I've challenged, all my grounds are challenged for within 34 to B, but I just remembered that 34 to A, this ground might also apply. The court will say, sorry, too late. You ought to have taken this ground under the section 34. The onus lies entirely on the party. The language of 34.b makes it clear that it is open, however, to a court while assessing a petition under section 34 to set aside an award even on grounds which may not have been taken by a party. For example, and this happens really on a practical level, parties and lawyers often weigh in balance what grounds I should take and what grounds I may not want to take, because I may also be equally responsible in the illegality being committed. We drop ground. But a court can later come back and say, you know what, I find that this award is completely against the public policy we did. The two of you might be okay with it, but it's a question of public policy. Why will I not set this aside? And therefore it is open to a court to adopt that mechanism. In fact, that mechanism has well been adopted by the Honorable Supreme Court previously. There is a judgment, her ladyship has Himakoli, who authored the judgment, and in rather clear terms has held. What happened there was, and I just give a brief of the facts. What happened was a party challenged the law under 34, but the 34 was dismissed. And one of the major grounds which ought to have been taken was not taken. I am not casting an aspersion that the party did not deliberately take it, possibly did not take it by mistake, or under legal advice. The ground was in fact taken in 37 when the order of the 34 court was challenged. The division bench of the High Court took the view that, look, you never took the ground under section 34. Now why is that relevant? Because, as you all know, 34 has a limitation period, 120 days maximum. Courts have taken the view that even an amendment to take fresh ground in your 34 petition will not be allowed after the 120-day period has passed, because it has happened previously, where a bare petition is filed on, say, on the 118th day. Listed, I'm not even saying filed in defect, which lawyers will understand, or not filed in defect, in fact filed. 5-6 grounds taken. And maybe on the 140th day, an amendment application is presented saying that, you know what, I forgot to take the next 25 grounds. I will be taking 5 days. Of course, that's sorry, this is not permissible. You can't come up now. The period to file your petition under section 34 is long gone. So had you presented the petition today, I would have had to dismiss your limitation law. So why should I allow you to raise new grounds today? This aspect, however, was ultimately settled by the court. And the judgment in question is state of Chhattisgarh versus Sal Udyog Private Limited. This is a 2021 judgment of the Supreme Court. And the court said, what I gave a brief of the facts, 34 no ground taken, 37 the ground is taken. The High Court said, look, I'm not going to introduce this. This amounts to a virtually a fresh ground, virtually a fresh 34 issue entirely. Why should I? The Supreme Court, the matter was carried to the Honorable Supreme Court. The Supreme Court took the view that, look, the language under 34(2)A is different. The party has to stand. But under 34(2)B, the court has to fight. Now, therefore, if I, applying my independent mind to the amendment in question, or the ground in question taken in 37 for the first time, I find that this is valid ground to set aside the award, I can't close my eyes to it. And in fact went on to say that that was a case of patent illegality. Now, of course, previously ONGC versus Law Pipes provided patent illegality should be a ground within the words public policy. That's now been modified. The illegality ground falls within 34(2)(a), and therefore does not apply to international arbitration. Be that as it may, this was a case of domestic arbitration. The court said that the High Court ought to have invoked its powers under 34(2)(a) of the Act. And since the award was patently illegal on this ground, ought to have said such. So therefore, the language of 34(2)(a) as opposed to 34(2)(b) is entirely different. One will have to bear it. The other aspect of 34(2)(b was 34(2)(a) of delegates. It does not entail any review and merits at all. 34(2)(b) is really a review and merits, albeit the jurisdiction is limited, but it will require a review and merits. So therefore, yes, it's true that a party can't start reading his claim petition. It's true that a party can't say, but you know what, I led evidence which has been misinterpreted by the government, all that can't be done. But the courts have expounded upon the words public policy. The courts have expounded on the words illegality or patent illegality. According to me, the previous view, and this is of course just a personal view, please don't take it otherwise. According to me, the previous view, which was set out in ONGC versus Sawpipes and Western Gecko, was possibly the correct. The reason being that although Section 34 is limited in its scope, there ought to be some level of interference by a court in arbitration proceedings. This is of course a personal view as I started by saying. And this, I had written an article on this question a couple of years back. And interestingly, you will find under the new act, which is now proposed, an appellate arbitral tribunal is contemplated. In fact, such appellate arbitral tribunals have previously been contemplated not by law but by agreements between the parties. There have been agreements that I've come across where you will find that the parties have agreed to submit their disputes to an arbitral tribunal and have privately set up an appellate forum, which is permissible. In fact, you will find that a lot of stock exchange bylaws, the SE bylaws, the BSE bylaws, both have arbitration clauses. The bylaws have arbitration clauses between locals, customers, etc. And those bylaws then provide for an appellate tribunal. And against the appellate tribunal, you go in Section 34. So it is an extra element of scrutiny provided. And this scrutiny is required because, as my friend had pointed out, there is always a problem so far as the losing party is concerned. You see, we've all seen it. Even the Honorable Supreme Court has several occasions to say that the law set out by me in my previous judgment is wrong and it was correct. So why should we assume that the arbitration tribunal is correct? More often than not, is not correct. That's again. But therefore, one level of judicial scrutiny is essential. Again, a matter of pursuit. Yes, you can always say, you chose arbitration, now you will protect. That's the usual. No, that's it. But the party chose it. The point I want to make, but you must remember that arbitrations today are not for 10 lakhs between the two of us. They run into thousands of crores. They can result in civil death of a company. Now, I frankly don't see, for example, in the DAM EPL arbitration, where the curative was allowed and the money's company was told, sorry, you're not getting the Now, I'm not going to go into the merits of it. Everybody has a different opinion on curative, etc., and possibly exceeding my brief. But the fact of the matter is, it will, in my opinion, it may well constitute a civil death of the company, in view of the findings now. So therefore, it is always essential, according to apply, to have one level of judicial scrutiny beyond simply saying public policy. Because patent illegality, you will find the recent judgments of the Supreme Court, whether it be Sanyong or whether it be ONGC versus Discovery Enterprises, these are the two primary judgments which have recently come after the 2019 amendment. Now what has happened is by the 2019 amendment, the scope of judicial interference in section 34 has been narrowed even further. It was narrowed to begin with, but it's been narrowed down even further. Previously, the court had said in ONGC versus Slovak, essentially held that public policy will include the fundamental policy of Indian law, the interest of India, justice or morality. So justice becomes a very important element because it becomes subjective very often. And lastly, patent illegality. Because patent illegality previously applied to both international arbitrations and national arbitrations. Now it's been limited to national arbitrations because I agree with it. But the words justice and fundamental policy of Indian law gives sufficient play in the joints to a court dealing with a section 34 petition to say that, look, I find this against the basic notions of justice. So what's happened is just wrong. And you may say it's subjective, but the fact of the matter is law itself is subjective. Whenever a court applies its mind, you can take the same matter to 4 different courts and land up with 4 different decisions. So it is always subjective. But the fact of the matter is, once you have some element of subjectivity, it is open to court to at least where it finds that, look, in my reading, this is just not judicially correct. You see, ultimately you will find that arbitrators need not always be judicial justice. They may well be engineers, especially in technical arbitration. Now, an engineer dealing with the technical arbitration may give a great finding on, how the gradient of a hill is, or where the landing of an aircraft could or could not be. But his understanding of law may not be anywhere close to a law. He is not trained. Why should he? Whereas a court dealing with the matter will say, look, what he's done, he might be technically absolutely correct, but what he's done is absolutely unjust. What do I do? So I'll say this. Now that's been narrowed. Now the court said, the Supreme Court, in discovery enterprises, and the real paragraph you will find in discovery enterprises, which encapsulates the law after reading Venu Sagar, after reading ONGC SAW pipes, after reading Samuel, says that, look, after the 2019 amendment, the scope of our interference has been considerably narrowed. And the words public policy, which were expanded in SAW pipes, the words public policy, again, it's a word of art. It's underwent various changes. The earlier judgment of the point was Venu Sagar. Venu Sagar was a case of enforcement of a foreign award. And the court said that, look, while interpreting a foreign award, our reading of public policy, or the words used in the Act, the Foreign Awards Act, we will narrowly construe it. Because we can't impose our public policy on a foreign award given somewhere else. Now, ONGC versus SAW pipes expanding this one, saying that, look, we are dealing with domestic awards. We are not dealing with foreign awards which were being dealt with in Venu Sagar. So why should we limit ourselves to Venu Sagar in that sense? Unfortunately, you will find both Sangyong and ONGC versus Discovery Enterprise. For one reason or the other, I find ONGC participates in all these proceedings. Be that as it may. In Discovery Enterprises, the court has gone back to themselves, without possibly noticing that Venu Sagar was a case of a foreign award enforcement. And therefore, the court only had to see whether it falls within the narrow scope of public policy in India for purposes of enforcement, not for setting aside. There was no setting aside challenge. Be that as it may, in Discovery Enterprises, the court in substance has said, and I'll read this because the wording is rather important. It says, a mere contravention of substantive law is not a ground to set aside the award. So you as a counsel in section 34 proceedings may argue, and sir, the award is contrary to section so-and-so of the Contract Act. It is open to the court now to say, but that only constitutes a violation of substantive law. I can't set aside the award. So therefore, an award will be illegal, but it will have to stand. Unless you fall within the bracketed patently illegal law. Now, patent illegality again constitutes some amount of subjectivity. But while interpreting that, once the court says mere contravention of substantive law is not enough, What do you do? But the court then goes on to say in the same judgment that if an award is contrary to a binding precedent, it will be cited. So therefore, what I can do is, I can find a judgment on a substantive law provision and say that the award is contrary to this judgment, and therefore it has to be set aside. It's illogical. It's our job to find it. The next, of course, and this is settled, the court will not reappreciate evidence. But there is a fine distinction, although the court may not reappreciate evidence, if the tribunal has not considered evidence on record at all. See, one thing is that the tribunal says that, look, on balance, I have considered all the material, and on balance, I find this side's evidence is better than that side. I'll go with it. The court will not reappreciate because that constitutes an appeal. It's not evidence. But supposing one party says, sir, I led expert evidence on damages. I led 3 experts. They're not even mentioned in the award. And the tribunal comes to the conclusion that I find that there is no evidence to grant damages. But there were 3 experts who led evidence on damages. Then the court can say that, yes, the tribunal has ignored vital evidence. Ignorance of evidence is different from reappreciation. Similarly, the construction of a contract will always be within the tribunal jurisdiction. But it is still open to a court to say that the construction of the contract is perverse. It is absurd. For example, parties agree, it might be a rather basic example. Parties agree that, look, in the event of war, we will not be able to deliver these goods. The contract specifically says. Watering down the contract, the arbitrator says, look, although the parties have said that in case of war, party A will not be able to deliver to party B, I find that the war had no real effect on the shipping route in question. Possible. It will still be open, according to me, for the court to say that, look, you've gone completely against the contract. It's not a question of interpreting the contract. Because the contract may constitute an absolute bar. In case of war, don't live. End of the matter. But if the language of the contract is somewhat different, for example, the contract is hedged in with conditions and requirements, saying in the event of war, and in the event shipping routes are affected, etc., etc. Or in the event of war, if one of the parties is affected and is unable to make delivery, then he will stand absorbed. Then that falls within construction contract. Then it is for the tribunal to decide whether there was an effect on the parties. Then the court can't substitute. There is a difference between an absolute bar and coming back to the construction of the contract. And the last is, of course, an alternate view, which is really an appellate court's discretion. So, for example, if we go to court, we file a civil suit, and appeal, civil judge decides, or the trial court decides one way or the other. When you file an appeal, it is open to the court to substitute its opinion for that of the trial. It is open to a court to say that, look, on the same material, I come to the opposite conclusion. Or, for example, the trial court has given 100 rupees. I find that the trial court ought not to be given 100 rupees, it can only be 80 on these facts. The appellate court can substitute that. But against an arbitral tribunal, when you go to the court cannot substitute. Now, there are problems with this approach as well. Hakim was brought up by my friend. Hakim was the NHA, and I'll try and close this up because I'm conscious my time is running. So far as Hakim is concerned, that says that the tribunal's opinion cannot be modified by the court. The court can either uphold the award or it can set aside the award. It is not open to the court to say that, look, according to me, on these facts, you've got 1,000 crores, you possibly could have got 700 crores. Not more. That is substituting opinion, reappreciation of evidence, etc. There's a problem with that. And the problem is I've actually done a matter where round one, the award was set aside. At that time, Western Gecko held the field. And the court said that the arbitral tribunal has not followed the judicial approach. And therefore, I'm going to settle it. The award was set aside, carried up to the division bench. 6 years passed in 34 and then 37. Ultimately set aside. Parties re-invoked arbitration because that's your own option. What happens is if you can't modify the award, you still have disputes pending because the award is gone. So you have to re-invoke arbitration. Parties re-invoked arbitration. After 1 year, an award came quickly enough because the pleadings etc. were all there from the previous arbitration. Parties chose to adopt it. That award was then again set aside, saying but the arbitrator in this case was unilaterally appointed by one of the parties. So round 2 opened. Round 3, parties are saying we spent more on the arbitration proceeding than we might have got in resolution of this dispute. And of course, 11 years have passed. So there is a problem with appeal, which is possibly why the Supreme Court is reconsidering the judgment in the constitutional bench today. The flip is equally true, and the flip is that to say that the court can modify the award, the court will then have to say that I have the power to re-appreciate it. So both approaches have a problem. The fact of the matter is to substitute your opinion or to modify an award cannot be done on the face of the law. Now, Discovery Enterprises, one thing I possibly failed to mention is Discovery Enterprises says that a 34 court, while deciding a 34, will have to see that all these problems, patent illegality, public policy, etc., have to be seen on the face of the award. So you can't say that, look, I am filing a 2000-page 34, including the entire arbitral tribunal's record, and I will show you from the evidence, from the pleadings between the parties, etc., why this award is there. Discovery Enterprise says, show it from the face of the award. Unless, of course, you can show from the face of the award that, look, evidence which constitutes X, Y, Z does not even find mention in the award. But then again, that's on the face of the award. So while setting aside, you will see the face of the award. But can you do that while modifying it? Almost never. For the simple reason that to modify the award, you will have to go back to the evidence and reassess as to what could or could not have been done. So both approaches will have problems. But at the same time, both approaches will have to be reconciled at some stage. We cannot have a situation where we introduce arbitration, saying that 1 year plus 6 months is the period for a tribunal to pass an award. And the entire point of arbitration is to save time. But we have round 1, 2, and 3 of arbitration running into it 15 years. And parties will say, I'd rather go to a civil court and get my dispute resolved. This really constitutes the distinction between 34 to and 18. Of course, the issue came up with a award is final. Let's face it, in our country, and possibly in every other country, nothing is final. There is always a loophole somewhere. Finality, I remember this saying, and this is mentioned by Justice Prasad in one such meeting where I was part of the world. And he said, the Supreme Court is not final because it is correct. It is correct because it's final. That's all. So the last person that we can call final is the arbitrator. He is the bottommost rung of a long judicial proceeding. That perhaps closes my time as well as my
heard then, do you think you are clear on what Section 34 interference should be? I think I get more and more muddled the more I hear.
Yes.
You know, and that's why, I mean, it reminds me of those words again of Justice Bhagwati in 84 in Guru Nanak Foundation, when he said that, you know, all this arbitration is getting embroiled in so much of legalese that, you know, it makes the legislature weep and the lawyers laugh. And that's exactly what is happening. Anyway, so I mean, in fact, when we talk about modification, Supreme Court even uses Article 142 and says, look, the matter has been pending for 25 years now. That is a China technology. And said, look, we'll modify the one. So all kinds of things can happen. But so therefore, when he says, where is the finality? Supreme Court said that. We are the last court, you have nowhere else to go. But even Supreme Court itself is not clear. You know, you'll have all these views and now going to a larger bench. You know, I don't know when the law will ultimately get settled, and it was meant to be what? Alternative to the court litigation? You are back in court. So,
fastest also becoming more delayed.
yeah, that's why mediation today, like, you know, people are, and one of the reasons why mediation works, because of litigation. People are tired now, enough we have spent in court, let's move on with our lives. And that's where sometimes, you know, so as litigation settlements are concerned, I said, courts are looking at those settlements, why? Because they want those dockets off their back. And so parties now really want, enough is enough, let's move on. And that's why those settlements happen so far as court litigation is concerned. But yes, mediation has a different role to play. Yeah, so we can now open for questions. Yeah, please go ahead. Can you have the mic? Your name and then.
Good morning, sir. My name is Raj, and I have a question for both Akash and Mr. That first, when we're talking about the procedural part of 24(2)A, and when you rightly pointed out that it has to be the arbitral tribunal's record that has to be considered, but when you talk about the issue of notice being provided for appointment or arbitral proceeding or the incapacity to participate, that burden cannot, as you also pointed out, applicant who has not participated cannot, present that proof that I was not served the notice. So for that first part, as per me also says that you should not have the burden to prove, you can only make a pleading that I was not served, and the arbitral record cannot itself suffice to say that I was properly served with the notice. But even if we go by the principles of CPC, that also says the person who is initiating the claim and the person who is serving the notice has the burden of proving that the notice was served. So that aspect, don't you think has to be, as you also pointed out, that is a lacuna there, that I can only plead that service was not done, but the burden of proving proper notice has to be on the person or the judgment decree holder for that reason, for the court to interpret or go into the fact that proper procedure was followed or not. So that's my understanding of the law being incorrect on that part, of me to prove under 24(2)A and having the burden.
So, there's a slight distinction between what I said and perhaps what you said today. And that distinction is that even if you see the principles of Order 9 Rule 7 or Order 9 Rule 30, which is possibly what you're referring to, it is always upon the party to establish that, look, I was not served with notice. The distinction is that you will find that in a court proceeding, the court's record is rather strict in the sense that whether you go to a civil judge, district judge, or to the High Court, you have an official court record which will establish on the face of it as to whether a party has been served or not. After all, the court would have, while entertaining the plaint, said that summons to be served by all modes or by electronic mode, whatever it is. And therefore, the court can see its own registry's record to see as to whether the order was complied with, whether the papers were sent or not. It may not be equally easy in a private setting, because a tribunal will simply possibly either send it itself or send it through the claimant to the defendant or one of the parties as the case may be. And this happens every day, that perhaps not the claim petition, but one application here and there is filed by a party. The tribunal says, please serve a copy on the other side. electronically it is sent, or now it is sent electronically. At least prior to the pandemic, it was rare for parties to send electronically. We always send physically by a courier, and we know courier receipts can be managed. We have a number of time. But to place the onus on the other party to say, look, you establish that you actually serve. How does he do that? He will only simply produce that receipt. The receipt is here. It's been served. Now it is for the party asserting non-service to say that look, I was not served because of XYZ reason. Okay. So the onus will always be on that party. What I possibly said was that I may not be able to establish it from the tribunals. There is a difference. The onus will always be on me. There's no doubt about it. After all, I am the one approaching the court. I can't say first ask him to establish the himself. I have, at least the initial burden of proof will always be on me because I am asserting a fact and I was not served. That's basic principle of the Evidence Act. The one who asserts a fact has to prove it. But I may not be able to do it from the record of the trial. I may have to produce additional evidence, which possibly when the legislature made the amendment, it did not apply its mind to issues of service of notice. You will find that the other provisions, for example, similarly party may not, I said, there are 5 clauses under 34(2)(a). You will find that the problem with basis of the record of the tribunal lies with 1 and 3. Party being under an incapacity and party was not given proper notice of appointment of an arbitrator. These are the 2 places where I may not be able to show it from the tribunal's record. The other 3 have to, in fact, will have to be shown from the tribunal's record this way or that. Because to show that the arbitration agreement is void, etc., I can't go outside the tribunal, obviously. This aspect will, of course, possibly have to be looked at, especially in view of the recent Delhi High Court judgment which says I can't look at any additional documents because of the language of 34(2)(a). You will, however, find that clause 3 deals with 2 parts: not given proper notice of appointment of the tribunal, or was unable to present his case. There are 2 entirely different things. I may be unable to present my case for various reasons. For example, during the pandemic, if a tribunal decided the entire matter on video conferencing, and one party being an 80-year-old man said, I will now not accept video conferencing, I have never dealt with a computer in my life. So therefore, I was not given an equal opportunity to present my case. The court may well set aside video conferencing. Of course, the onus will be on the party making that assertion to show that, look, I have no idea what a computer is. I couldn't exit my house because I'm 80-year-old man. I might have contracted the disease in time. Why should I take such a risk for an arbitrary disease? Be perfectly alright. So far as the first part is concerned, and you will have to bear this in mind when it talks about not giving notice of appointment of an arbitrator. Earlier, this was a major ground, and why this was a major ground was a lot of agreements provided for unilateral appointment of arbitrators, where one party had the power to appoint. Usually, financial institutions, government bodies, etc. They could simply say, in case a dispute arises, I will appoint, and you will have to go for arbitration. Now, in such a scenario where one party appoints the arbitrator, the other party may well tell you, I didn't ever serve. I didn't even know that an arbitration started between the parties. That problem is to a large extent diluted today because the concept of unilateral appointment is gone. You can't unilaterally appoint them in terms of Perkins, etc. So therefore, either the parties will mutually appoint an arbitrator, therefore both of them know that an arbitrator has been appointed. You can't say that I did not have notice. Or the court will appoint under section 11. Again, prior to appointment, the court will issue notice of the section 11 petition itself. Now it is for a party to decide whether he wants to oppose the petition or come for the petition or not. So therefore, necessarily the party will therefore have to establish that I was never served with the section 11 notice.
But then the third element where a private dispute is, we are just making a...
That is the only, that's the only place where this could possibly apply. Otherwise, either parties will appoint their respective and a tribunal will be constituted a third member. Both parties will mutually appoint or the court under 11 will appoint. Institutional appointments, yes, you are right. That is one place where this could possibly happen. But then again, the institutions which are appointing arbitrators usually have rather transparent records, unlike parties appointing an arbitrator, who will probably not keep a record. For example, you go to FICCI or you go to any of these bodies which have arbitral appointment systems. They will provide notice and they will contain, they don't entrust service of notice to a party. They do it themselves. They will have a record of some sort. Now, whether that record is sufficient or not, of course, will have to be assessed by the court. But the scope of application of this clause is rather limited now. It is only applicable to institutional appointments. And I have done several arbitration proceedings in the past. I have not come across one arbitration clause which provides for an institutional appointment. Not one. It is rare. It is only, especially in private contracts, parties just don't even apply their mind to institutional appointment. It is only where the entire contract is through an institution, that the institution says, but my arbitrator will decide this. Yes.
Because in arbitration where the court has not chosen something, because the annual period where the regulators get we were not so
Yes.
So that just put the onus on me to prove that you proved the service.
That's right. So what you will have to show is that if you say it is inoperative, then you must have received an email from the server saying that we are closing down your email address for
I
X.
know that part when you said it. That the onus part has been shifting in this aspect.
Now you take it.
It needs a long debate. Like,
Yeah.
can we have somebody else?
You can meet me outside.
Another question before, because you see, the more you deal with the sessions, you eat into your lunch. No, sorry, let's have somebody else also ask another question.
Yes.
Unfortunately, not. You can take just to clarify this.
Good afternoon, everybody. I'm Indijit Sidhu. I'm practicing at Delhi High Court. This question, in fact, not a question, it's a clarification for Mr. Mohan on section 34, part 2, subclause 1 and 2. Like, it's a very simple language I just need to understand. Like, if the party participates in the proceedings, the arbitration proceedings, and is aware of the fact this person is not competent or has incapacity to deal with this, chooses not to take that objection before the arbitrator, but if loses, takes the objection in the court. Can that be taken up? How that will be dealt? Can that be taken up in 34?
Yes, it can. I'll give an example. Arbitration need not just be commercial. There could be an arbitration arising out of a family settlement, for example. Now, between brothers, one of them becomes of unsound mind after the agreement is executed. So the agreement is valid. I'm not saying that on the date he signs the agreement, it is valid. Subsequently, he is diagnosed with unsoundness of mind. Some other brother of his gets a lawyer to appear based on a vakalatnama which is possibly, giving thumb impression or some signature is there. That is sufficient for a vakalatnama. Very often lawyers do not even verify. Arbitration goes on. The lawyer presents whatever he can present and ultimately loses for the person of unsound mind. That person of unsound mind, although on the face of the record has participated through the entire proceeding, may not even know what has happened in the entire proceeding. So therefore, he is welcome to challenge under 34(2)(a) or possibly a legal guardian. See, a person of unsound mind, even at the stage of 34, can't present a petition on his own. You have to be competent to present a petition even at that stage. So possibly his son, daughter, wife, somebody could apply to the court for appointment of guardian ad litem. The guardian ad litem will be appointed, and that guardian can then take the ground. But sir, when this entire arbitration proceeding took place, this man was of unsound mind. See, a person who is of unsound mind cannot take a decision for himself. That's the basis of the clause.
My question is, the other party knows and the other party loses. If they were aware this person was not capable.
No, that party can't.
That's what my
A
question.
party was under some incapacity will mean that the party who's asserting incapacity will have to do it.
They have not chosen to take that objection before the arbitrator.
Yeah.
But knowingly well that this was the situation, they take that objection in 34. Can that be done?
You mean the
The
party
was
of
aware. Yes,
sound mind
yes,
loses the arbitration?
yes.
No, according to me that
It can't be. that cannot be done.
No, because he was under no incapacity.
But if he if he said the onus is on the party who comes to the court,
Yes.
and if he is able to prove that I was not aware, but he is aware from the records, if it can be shown, but like again this has to be debatable in the court. Other party will say he will aware.
No, ma'am, what I am stressing on is that the party who's coming to court was not under incapacity. It was the opposite party who was under incapacity.
Under some
Yes. So
okay,
the party who was approaching the court may have to show that I was under incapacity, not some third party. The court will say, let that third party come. Why?
I'm only on this. The person who loses is aware the opposite party was not capable of entering into the or proceeding, participating in this arbitration proceeding, but chooses not to take this objection.
And still loses.
Still loses and come to the court.
You got a very bad one.
This happens.
Okay. Can we have one more question here before?
So taking forward our unilateral appointment discussion in an arbitration, where the arbitrator is unilaterally appointed and award is rendered, then the party, the award debtor will have to challenge the award under what provision of section 34A or 34B, or will it be void ab initio?
On unilateral appointment?
Yes.
On unilateral appointment, the law is that it's a void ab initio appointment. That's Bharat Broadband in case you wish.
So it doesn't have to be set aside under section 34.
No, in fact, the Supreme Court in Bharat Broadband says it's void ab initio. Following from there is a judgment of the division bench. Not Isola. There is the division bench is ordered by Justice Bakri, yes, which I will give you. That matter came. In fact, no 34 was filed at all. The person in whose favor the award was passed filed an execution petition seeking to enforce the award. The other party in the execution proceeding said that this award is a void ab initio since the appointment was void ab initio. The district judge said that, look, no, I can't enforce this award. The matter was carried in 37, not 37, sorry, in execution first appeal before the division bench of the High Court. It was a commercial matter, that's why it went to the division bench. The division bench said it's a void award. No need to file it.
But isn't that going against the essence of section 34, because it says only on these grounds?
Yes.
You have to meet one of these grounds unless there is an amendment to section 34.
Alright, so this is more a judicially created ground by virtue of Perkins. Initially, Perkins said that, look, if you can't appoint, you can't act. If you can't act, you can't appoint. That was carried forward in Bharat Broadband, and they said it's a void ab initio appointment. And the idea was to provide transparency in arbitration. Unfortunately, judicial experience has shown that, especially with financial institutions, etc., where they simply, after a loan is admitted, it's rare for a loan to be denied. Financial institutions were giving hundreds of arbitrations to a single arbitrator, who would simply, and we've experienced this as lawyers, you walk into the arbitration room and they simply say, "Paise ka paise." So it's not a judicial proceeding at all. It becomes a farcical proceeding. And then to say that, look, the limited grounds of challenge under 34R XYZ, and therefore you can't even challenge, was being really unfair to parties. After all, there are cases and there are cases. I've come across a case where, yes, the loan was taken, in a similar situation, loan was taken. A guarantor had signed the paper. But we established to the court that the guarantor was not even in India when 42 years his passport showed that he was not even in India and was shown to have signed these documents in the financial institution. What does such a party do? If we simply told paise ko paise. So therefore it is somewhat a judicially created ground.
Also,
But if I were to fit it into a ground, you will find 34(2)(a) 5 says the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties. Okay, sir? Or failing such agreement was not in accordance with this part. Composition can be a ground. But the courts have, rather than fit it within 34(2)(a) and fit it within 34(2)(b), saying that such an appointment itself will run contrary to the public policy of India, and consequently we will deem it to be a void appointment. So it's a 34(2)(b) issue. That's how it started out initially. Subsequently, since Bharat Broadband went a step further and said that it's a void ab initio appointment. Therefore, there is no appointment in the eyes of law at all. If there is no appointment, there can't be an award. If there can't be an award, there can't be a 34 challenge. So you can't say a 34 challenge is mandatory to set aside a void appointment and avoid it. It progressed over time, between 2016 to 20.
However, that's in the light. Also, it's in the light that the ineligibility of an arbitrator can be waived off. So can we say it will be void ab initio because if
except
it is
in
waived
case
off,
of express waiver in writing.
Right.
That's the language of 12.5 proviso.
Right.
That there has to be an express waiver in writing after the disputes arising, not in prior. So prior to the disputes arising, even if I write saying that I have no objection, if in future any dispute arises, your managing director can do it. The court says this is prior to disputes having arisen, it has to be after disputes having arisen. So parties consciously raise disputes. One party says that, look, do you have any objection if I appoint X as the arbitrator? And I say I have no objection in writing. Then I am deemed to be expressly waiving my rights under 12.5. That's how it will have to be seen. So it's a void ab initio appointment unless it is expressly waived.
So I'm sure you have several questions, but we are running against time and going to get into the time of the next session. So we're going to have a break. Thank you, Akash. Thank you, Ashish, for such a beautiful exposition. I'm sure it clarifies. I'm sure, but where we are, I don't know. So we will have a small break. Break means we need to be back by 12:15, and let's not use it as a tea break. What I learned in UPS, what we learned in UPS was we can call it a bio break. Yeah, before we go for a bio break, can I request Sarita? Small presentation from our side of appreciation.
I would like to call Ms. Pooja Anand to felicitate Professor Akash Gupta. May I now request Ms. Abha Malhotra to felicitate Mr. Ashish Mohan, Senior Advocate.
As a small token of our appreciation. Thank you so much for being here, taking out time. Akash. Thank you. For a quick break and let's be back.
Yes, it's a tea break for 10 minutes only. Please be back on time. Thank you. 5 minutes. ये डिस्टर्ब होगा ना फिर हम एडजस्ट कर लेंगे इधर कैमरा डिस्टर्ब होगा कैमरा डिस्टर्ब होगा वी विल मैनेज हु कैन मैनेज And as I said, you have the profiles in your booklet. I'll just quickly introduce our two faculty. Dr. Apurva Dixit stands as an exemplar for academic excellence and professional distinction in the field of law. She is an accomplished scholar and a practitioner, and she currently serves as Assistant Professor Senior Grade at School of Law, G.G. Goenka University, Gurugram. where she has earned a recognition for her dedication of legal education and dispute resolution. Dr. Dixit's impact extends beyond academia. She has recently served as a research fellow with the Ministry of Law and Justice, where she contributed to critical areas of law making. Currently, she mentors legal professionals as a part of JSEP course at Live Law, continuing her mission to inspire and shape the next generation of legal minds. Dr. Dixit's remarkable career epitomize innovation, intellectual rigor, and unwavering commitment to the advancement of justice, leaving an indelible mark on the legal landscape. Mr. Gaurav Pachnanda is an eminent senior advocate and a luminary in the field of commercial litigation and arbitration. He is renowned for his exceptional legal acumen. Mr. Pachnanda practices a broad spectrum of commercial disputes, arbitration, and advisory work, often involving high-stakes, multi-jurisdictional complexities. Mr. Pachnanda is widely respected for his thought leadership in commercial law in India and abroad. His remarkable career epitomizes the highest standards of legal excellence and scholarship. Over to you, Apurva, to take the session.
Thank you so much, ma'am. Good afternoon, everyone, and I wish a very warm good afternoon on this very Saturday morning. As you've been introduced, I am Dr. Maadhyam. The topic of discussion today is going to be what will be the effect of any of an international arbitral award being set aside by the Delhi High Court, both on jurisdiction and seat of arbitration or further arbitration and the same disputes and fresh arbitration. Please, I apologize in advance. I do not have that strong meme point with respect my friend Akash. It's going to be plain beauty, but a lot of discussions. So now the topic, I am further divided into certain parts, and as a person from academia, I have a habit of asking a lot of questions, so please be ready. I will be happy to take your input and then putting my opinion in order to have this discussion altogether. Now the objective of this session today happens to be to explore the impact of setting aside the International Arbitral Award by the Delhi High Court, both on the basis of jurisdiction and seat. Why this is topical matter? Because the relevancy in the context of international arbitration and India's growing prominence as a hub for dispute resolution. What is the seat of arbitration? I'll quickly skip the slide and then ask you a question. Do you know what is the seat? Not the seat which you're sitting on right now, but what is the seat? Anybody? And there are no wrong answers, there are only opinions which can perfectly be correct. Anybody? What is the seat?
Where the arbitration takes place.
Where the arbitration takes place. Okay, sir. Then what is the venue? Place. And what is the venue?
You may agree with the arbitral tribunal to conduct proceedings elsewhere.
Absolutely. So the geographical location broadly can be called as venue. Venue. And the seat is called as the law which is going to govern the entire arbitration. So the seat of arbitration refers to the legal jurisdiction that governs the arbitration process, and it determines the applicable procedural law, judicial oversight, and the legal framework under which the arbitration is conducted. What's the legal significance? We all have heard of the term lex arbitrae. I will still call myself as a student of law, and so are you. So what is lex arbitrae? Clearly mentioned over the slide as well. Does lex arbitrae govern the entire proceeding? Yes, or maybe. Yes. Right? So now the courts of the seat have the authority to intervene in certain aspects when we talk about of the arbitration, such as appointing arbitrators, granting interim measures, or setting aside the arbitral award. Now, for example, if Delhi is the seat of arbitration, what will be the applicable law? The Arbitration Conciliation Act. Understood? I have this habit of saying this. So now the kind of awards we are going to discuss over here is Indian origin, and the legislation is happening only in India. What is international award? According to many of the proceedings, the arbitrations which are having seats in India are also known as international award. And foreign award, for our clarification, happens to be those awards that one of the party is not from India. As defined under section 2(1)(f), international commercial arbitration, one of the parties has to be from any origin other than India. If the arbitration is seated in India, section 34 of the Arbitration Conciliation Act will govern the challenges. Consequently, if we are talking about any arbitration which is seated outside India, the enforcement of the arbitral award will be subject to the provision of section 48. The key ground has already been discussed by Professor Akash here. I'll just go through the entire list: that lack of proper notice, partial or corrupt award, ultra vires award. These are the grounds based upon which an award can be set aside. Violation of public policy or contravention to the basic notions of morality or justice. These are the few case laws. I am sure this PPT would be available to you. These case laws are specifically talking about the section 34 analysis at depth. Now, what are the circumstances? We know that there are certain set of similarities associated with section 34 and 48. Am I right or am I right? If you broadly look at it, section 34 happens to be exact replica, and we believe in replicas. Because, no offense, but Amsterdam model law has been our guardian, has been our sole god with whose, let's just say, approval and whose, we have created that as a Bible in the Arbitration Conciliation Act. We did not even bother to change a lot of names. Article 7, Section 7, am I right or am I right? We did not even bifurcate on that. Why do we have to even challenge it? You said it, we have to make it, we'll do it, boss. So now when we talk about it, section 48, which actually refuses to enforce the foreign award, is on the basis of incapacity. We have discussed incapacity in the previous session at length on a lot of points. Now, if the parties to the agreement was under certain kind of incapacity, or the arbitration agreement was invalid, or there was a lack of notice or proper opportunity, ultra vires award, procedural irregularities, or award not binding was set aside. These are the prime reasons based upon which an award can be set aside. Sorry, can be not be enforced under section 48. Any idea what is section 48, the heading? You all have the direct with us. And this comes under what broad heading it is there? Which convention? Absolutely, yes. There are two conventions broadly, New York Convention and Geneva Convention. The primary idea for us is to understand that if an award is not an Indian award or domestic award, what will happen? We talked about setting aside an Indian award. But can we set aside a foreign award in India under section 34? We agree? You've heard of the two terms, finality and enforcement. Yes? Can anybody give me a difference between the two? What is finality of the award and what is enforcement? Yes?
Finality means something which can be imposed as a decree. For example, under the old Act, you have to make the award the rule of the court to make it final. Now, under the new Act, under 35, the award is final, right? And you can enforce it under section 36. So enforcement is the next step. Once you have a decree from the court, then you can enforce it by execution in a domestic proceeding, and then enforcement in under section 14 if it's a foreign law.
You just made my work easy. Finality of the word is actually what can I get it? Aditya said. Is it actually means to the conclusive nature of the arbitral award? Who makes this award final? The tribunal. Meaning that the enforcing courts cannot act as an appellate court and cannot look into the merits of this. Now, while we talk about the legal implications of the finality, once the award is final, it is binding on the parties. The arbitrator's jurisdiction ends after issuing the final award, right? And they cannot modify it, except for the grounds which are clerical errors, computation errors, or certain parts of which have been omitted, which is supposed to be a part. Sometimes it might happen that discussion were at length and things were discussed, but it did not reach up to the final award. In that situation, the arbitrator can do it at the application of one of the parties. Now, challenges is there while an award is considered as final. It can still be subject to challenges, such as setting aside proceedings on the basis of limited grounds. Now, while we talk about enforcement, as I just discussed about section 48, that on what grounds the enforcement can be resumed. Enforcement means actually refers to the legal process of making the arbitral award executable by the court. Under which section does enforcement happen? I had different. 36. And what happens if it's a court award? Can we get it enforced? 49? 48 talks about the grounds for refusal for enforcement. I have such an intelligent group of participants that are very happy. Because a teacher or legislator happy every year, we are very happy when the ground is interactive. We have been through the COVID times where we were only talking to the screen and the screen was looking at us. What do you want to say? Jokes apart. So now, if we talk about the legal implications, as in that even if the award is final, it may need to be enforced to the courts if the losing party does not. Can you tell me that if I have the award, I am the person who has received the final award, and I do not take it to the court, what will be the fate of the award?
You'll have that finality to the binding.
Do I really need to go to the court?
No.
Is it automatically binding?
Yes.
Yes.
Do you have a relevant section to prove your point?
There is no appeal that is filed against an award when it attains finality.
I'm asking for the particular section. I am saying that if I get an award and I do not get it enforced, I have the award in my favor. What would be the next step? And if I do not take any other step, what will be the fate of that award?
Wait for
Sorry?
Wait for objections to be filed or not filed.
That's a valid point, ma'am. Now, let's keep this as some food for thought and come back to it later. Now, while we talk about the challenges to enforcement, the losing party can oppose the enforcement on the limited grounds that are provided at the New York Convention as well. Now, what are the consequences of setting aside an arbitral award seated in India? If you do not take that to look at the slide, I know that it is impossible, but what do you think would happen? What will be the consequences of setting aside an arbitral award seated in India? Sorry? I'll just go back to the slide.
So objections are not filed, and after the limitation period is over, then for file for the enforcement of the order.
All right, ma'am, point taken. Anybody else?
If it's set aside, then you raise the dispute afresh. So basically, if the dispute was decided to ask the somewhat or if it is set aside in totality, then you to raise the
I did get your point there. So let's now actually come to the part that if the award is being set aside, there will be invalidity of the award. On what basis? Once an arbitral award is set aside, it becomes invalid and unenforceable. The award loses its legal effect and the parties cannot rely on its enforcement on decided fields. Do we have the provision to actually, once the award is being set aside, we can challenge it again? There are limited grounds for appeal. Right? What are those sections? Anybody can read it. There are 5 to 6 provisions only under this section, under section 37, appeal can be filed. Section 9. And 16 and 17. Right? So this is a limited scope of appeal which we have under the Act. I'm a very critical thinker on the aspect of arbitration conciliation act, and whenever I discuss with a lot of our peers and students, we come across with certain loopholes. That topic has to be discussed in detail somewhere else, but yes, certain aspects which are open to interpretation comes across as a loophole as well sometimes. Now, while we talk about the possibility of fresh arbitration, do you think there's a possibility once the word is set aside, can the parties move to fresh arbitration?
Yes.
Does the consent part matter here, or only one party can do it? One party can do it? Both the parties, the consent part is there. Because ultimately, the sole whole ground of having arbitration is the arbitration agreement where the consent part is the most important one. So now, possibility of fresh arbitration is actually there, but does not necessarily preclude the possibility. Let's just say that the parties may opt for a fresh arbitration to resolve the dispute, provided that the arbitration agreement remains valid. Because let's just say, in the absence of an arbitration agreement, you and I both will agree there cannot be arbitration at all. Arbitration clause, arbitration agreement, arbitration by reference, anything has to be there in order to initiate or rather reinitiate an arbitration. Judicial proceedings. The court may impose conditions or directives depending upon the grounds for setting aside the award to ensure the justice is served, such as corrective procedures, lapses, or addressing issues of fairness. Sometimes it might happen that the certain part of the award which does not make sense rather can be kept aside, can be omitted, and the remaining part can be taken away and then be imposed. That option is also there. Challenge and appeal, obviously, like we discussed right now, that there is always a process of appeal and challenge which could be there at a legal level. Cost and damage. The party against whom this award is set aside may be liable for cost or damages if the court finds out the award was set aside due to procedural misconduct, fraud, or corruption by the prevailing party. The opposing party may be awarded compensation. That entirely depends upon case to case. This is something, these are the exceptions, or let's just say the broad areas which can be applicable to certain situations, if not all. Now, impact on arbitration agreement. We completely know that the arbitration clause or arbitration agreements have their own validity, even if the main contract goes invalid or illegal or unlawful for any purpose. Setting aside an arbitral award does not affect the validity of the underlying arbitration agreement. Parties can still further arbitrate the quarrel disputes under the same agreement until under it is declared void. Same has been repeated in the present case. Now there are different opinions which have been cited. Sometimes if you come across the judiciary, it is open to interpretation as well. While we talk about the ratio or the arbiter dicta, there are differences of opinion which have been showcased, and that's the beauty of our Indian judiciary. Everybody has been given their interpretation to the subject matter. Let's just say section 34 itself. Today you're going to have 3 sections on one section only. 3 sessions on one session, and the entire day you're going to only talk about section 34, and yet in all the 3 sessions you're going to learn and read something different. And that aspect which have not been covered. Now while we talk about this Arbitration Conciliation Act, this BEAR Act does provide us the entire framework, but we have to look at the practicality part of it, and sir will agree in some time when he deals with this part, that there are certain nuances which are not even covered in the Arbitration Act. Like the example which was quoted by Shivansh earlier, that situation cannot be found in a textbook. These are not textbook questions, and that is why the practicality part has to be merged with the theory part. Right? If I say on paper that section 7 has the validity of arbitration agreement, okay, there are certain essentials which need to be followed in verbatim or in toto. But there are certain interpretations which are made out of that from judiciary that also makes an impact and has a lot of credibility associated with it. Right? We rely on precedents, we rely on judiciary for the matter of fact that not everything can be interpreted with a bare answer. Now, in this case law scenario, Mullik versus Ghanshyam Das, it was observed that the Act allows the courts to remit an arbitral award back to the tribunal to rectify the grounds for setting it aside. How can that be possible, theoretically? Do you think any case law can, any section apart from this can actually help us in understanding this provision? Okay, we'll come back to it later. This discretion cannot be exercised through a motor and must be invoked before the arbitral award is set aside. If no such application is being made or found appropriate, the court proceeds to read the petition and may decide to set aside the award. Now, different interpretation has been held in McDonald. It held that it cannot, section 34 of the Act, it cannot correct errors in an arbitral award, but it can only set aside, allowing parties the option to recommence arbitration if desired. Difference of opinion, but they are perfectly correct opinions on them. Now, what are the consequences of refusing the enforcement of a foreign arbitral award? What do you think are the consequences? This time I was sharp enough to remove the slide for you. Otherwise, I'll give you a hint. What are the consequences? I gave you a tablet earlier as well. I asked a lot of questions. Please.
it affects trade in general if it's domestic.
Just be a bit louder, sorry.
I mean, if it's domestic, in that case, people won't resort to arbitration. They'll lose
We
trade.
talk about foreign arbitration.
If it's foreign arbiter, then even then, in that case, like it affects countries from entering into BIT, for example. People really resolving to settling disputes by arbitration.
Alright.
Yeah, just trade.
Point taken. Anybody else? What becomes unenforceable in the refusing jurisdiction? Can anybody explain this point from my side? Apart from the explanation. Yes, sir.
For example, one distinction I would like to draw is earlier there was a case law called Maadhyam versus Venture Law. In that case law, India used to set aside international awards, foreign awards.
Yes.
So, for example, in that was setting aside not refusal to enforcement. I'm just drawing an analogy. So, for example, if an award is set aside by a competent court, then the award does not stay at all.
Right.
But for example, if an award is passed in France and someone comes to enforce it in India, and India doesn't set aside, just refuses to enforce it, but the main award still stands, and if the same company has a property in some other jurisdiction, then the parties can try their luck in that jurisdiction and recover the amount. So, in international arbitrations, multi-jurisdictions, so you can try your chances in different jurisdictions. Of course, there are some case laws like venture which sets it aside, then the consequences might be different, but it's no longer good law. The Palco is there, luckily.
It's like saying ये jurisdiction नहीं तो कोई और नहीं. Thank you so much, sir. It cannot be wrong. That is it.
So I think the very authenticity of that very bench, whatever international platform it is or whatever international arbitration bench standards, I think first the authenticity of that bench, the judges who are sitting or the former judges, etc., howsoever it works to do on the bench, the authenticity of that bench, the application of law of that bench, the acumen of the judges to bring justice to that commercial matter is under question and scrutiny itself. That's the first thing. Right? I don't know, I'm not at all into arbitration. Just thinking loudly.
Please speak it up.
And second thing, just two small points, ma'am. Second thing, I think, when we talk about consequences, the very word consequences. So what happens? There is a derailment and delay to the So there is a derailment and delay, both for the commercial parties. And understanding that in commercial law, time is the essence. Right? That's the second humble point that I have. And finally, to conclude, when we talk about refusing, so when the parties are refusing that award, it's a very big question. Because both the commercial parties have invested time and have invested money in the lawyers, which is expensive, huge fees to the lawyers. And when you talk about international matters, so there is an exorbitant amount of fees to the law firms, right? So to conclude, the third point is that refusing. So it's a very big question when parties are refusing the authenticity of the application of mind of the bench. It's a question of value. So all I can conclude is 3 points.
Certainly, your points are very well taken, and we do not disagree or agree right now because that's a lot of topic of discussion at depth. So we will certainly take it up.
Thank you.
Now, as Aditya has clearly mentioned out one of the points from Nano University, Sadhya has also put forward her opinion. Now we move to the next part of possibility of enforcement in other jurisdictions, like Aditya was saying. If one jurisdiction is actually set it aside, the parties have the option to go to the other jurisdiction as well. Now, implication for the creditor. Who's the creditor here? Akash explained it. If you are the person who's the creditor, what do you think is going to be the implication on you?
Financial loss.
Time gone, money gone, in general. Right? Fresh proceeding. I had entered into this arbitration because I wanted to save my time. But if this happens, I am going to go in that loophole again. I will have to start again from the scratch. The creditor may have to incur additional legal costs and delays as they might seek enforcement in other jurisdictions and explore alternative legal remedies. I think at this place, the the multi-tier dispute resolution clause really help. Having friends seated like outside India, they really tell me that in UAE and as well as Europe side, multi-tier dispute resolution clauses are taking a, let's just say they're becoming very new and people are adapted to it because they want to explore more options. Okay. Now, is there a potential for appeal in this situation? Absolutely right. It's written. I see, I'm a very liberal teacher, so I give hints as well. So now there is a potential for appeal under section 15. Now, what will be going to be the impact on international arbitration framework? What is the prime reason why India is still not being taken up as the seat for international arbitration? It is being taken up, but not in delays. What
It
else?
can also be the other way around. I'm sorry. I mean, I may be wrong again. I'll say because when you
You're
have
free
to
to
have
keep your opinion.
yeah, because you have to have a little experience in arbitration. I don't have that, so I'm just trying to think loudly. So it can also be that why India is not being considered, as you said, that question. It can be the other way. Maybe any other international award we are refusing. Maybe that would be a point, a brownie point, that if India is refusing to enforce any foreign arbitration award, being an international, though it's not an international bench, right? So in case if there's any matter of any commercial parties out there, I'm just thinking loudly. So it can also be that, if we have a resentment against any award, there will be some points at an international platform that why it is taking time for India to gradually evolve, to take into consideration all the international conventions as well, when it comes to entering into an agreement, etc., or even recognizing for that point. That's all.
Saturday, you have really good thoughts as a compliment. And if you are you practicing or you're a student?
So I had this very honorable holding blessing to assist and generals a few months. So like, I couldn't get these thoughts other than from generals.
Rest in peace, not
training. That's it. Thank you.
So now, absolutely, we appreciate your thoughts and your mindset. Now, let's move to the next ground. That's a ground for refusal. That's the next consequence. Now, what is the ground for refusal? Or what? Please stop reading this title.
I think it's a broader version of 34 when you talk about the capacity.
They're like sister concerns to each other. As I talked about that section 34 and 48 are similar and not similar to the core extent, yes. That's the exact answer that you're looking for, Shivansh. Thank you so much. Now, while we talk about the comparative and international perspectives, the New York Convention allows enforcement of awards annulled at the sea subject to the discretion of enforcing courts. Jurisdictions like France and US have enforced the annulled awards in cases where the annulment was deemed inconsistent with the international public policy. So this has been happening around the globe. So this is not something which is new. There are few case laws that are mentioned here. I'll circulate the PPT for all of you to actually have an in-depth. I will wind it up soon now, for sure. For your reference as well. I am quickly going to conclude my part here. Now, while we talk about the model law, what is the model law? Which we have actually delineated in a class and we have actually got it down in the Arbitration Cancellation Act. It is silent on the consequence of setting aside an arbitral award with Article 34, allowing courts to remedy the award with the tribunal in certain cases instead of setting it aside. Similarly, in Singapore, English and Canadian laws don't explicitly address this issue as well. The Singapore Court of Appeal in this present case law held that the setting aside an award does not affect the arbitration agreement's validity under the English law. The annulment is drastic remedy. The court's empowered to vary awards when appropriate. And the German Arbitration Act explicitly states that setting aside an award deactivates the arbitration agreement with a dispute subject matter. Now you see there is a difference of opinion from across the globe. There's a reason why I am reiterating or reading the entire sentence as it is, because we need to understand what is the kind of analogy and interpretation done at the global level as well. Right? Now the Act allows the award debtor to challenge. I'm a commerce student as well. The minute I read debtor and creditor here, I was taken back to my golden rules of accounting. Honestly, debit what comes in, credit what goes out. So now while we talk about an award debtor to the challenge an arbitral award, it seeks its remission for curable defects While incurable defects like, for example, invalid arbitration agreement or non-arbitrable subject matter, it may lead the award to being set aside, allowing the parties to pursue alternative remedies. If an award is set aside for other reasons, then the arbitral process may recommence from scratch, often before a new arbitration. Now this restart actually undermines the arbitration's time and cost advantages, exposes parties to strategic disadvantages. Now prior disclosures and is complicated further by court findings on merit and influence. Now apart from saying all this, it's a very complex issue to altogether talk about it. And without taking further any more time, I'll quickly ask Gaurav to please take it up from here. Yes, sir.
I'll just speak from here. Thank you very much, Rupa. I think you've given a very broad overview of almost every legal aspect that requires consideration in the context of this question. The question, it appears to me, and I think it's very cleverly drafted, it can have several connotations. But if I look at it, the question as it appears to me, the person who's posing the question is asking us, what would be the effect of setting aside of an international arbitral award by Delhi High Court on the jurisdiction and seat if or can the arbitration be commenced again? Because of course, if the setting aside of the arbitration results in everything come to an end and there is no scope for a new arbitration, then it will have no impact on jurisdiction or seat because everything has come to an end. But obviously the question presupposes, is it possible to restart an arbitration? And if it is possible, then what will be the impact of an order of setting aside on the jurisdiction and seat in the arbitration clause? It's very important to understand how the law relating to seat of arbitration has developed in our country. Ordinarily, seat is a concept that is of great significance in transnational disputes when they go to arbitration. So there is a dispute that has a large part of the dispute in Singapore, some part of the dispute is in India, and some part of the dispute is in London. Parties then will face issues of conflicts of laws because at some stage the arbitration will come to an end. Which court will govern or which court will exercise jurisdiction on various aspects of this arbitration? There will be jurisdiction of a court to commence an arbitration, appoint an arbitrator, default appointment. There will be jurisdiction of the court to set aside the award. There will be jurisdiction of the court to decide procedural issues. Without going into different aspects, but the issue of seat becomes significant for the purpose of deciding which the right court would be for the purpose of deciding these issues. So in international arbitration, the concept is that if the parties designate a seat, then that will be the foundation or the source of jurisdiction for the purpose of finding out which is the appropriate court for appropriate actions at different stages of the arbitration. So if parties have decided that London will be the seat of arbitration, then even if the dispute relates to a large bungalow or a large estate in Singapore, it is the London courts that will exercise jurisdiction to set aside that award, because that is the manner in which international arbitration evolved. That is the very purpose of deciding what seat of arbitration is. The need to determine a seat, therefore, arises out of principles of conflicts of laws and conflicts of jurisdictions of various national courts. Within a nation, India or Singapore, if the dispute is related to a different part within that nation, so let's say in India, a dispute arises with respect to a property in Bangalore, you don't need necessarily a concept of seat because the jurisdiction of the court, at least for civil actions, is decided by domestic rules. And if you look at the Arbitration and Conciliation Act of 1996, as it was originally enacted in 1996, in Part 1, the concept of jurisdiction of courts was determined in a manner where the court that you could go to for the purpose of, let us say, setting aside an award, would be the court which, as per the domestic rules of our country, would have jurisdiction over a dispute. So let us assume, as I said, a property in Bangalore, two persons have an agreement to sell with respect to a large bungalow in Bangalore, and they had designated that the seat of arbitration will be Delhi. The arbitrators sit in Delhi, and the arbitrators decide that the property should be partitioned between the two of them, or there is an agreement to sell that the property should be sold by Mr. X to Mr. Y. Now, Mr. X wants to challenge this award. Ordinarily, the initial evolution of jurisprudence under the Act was that it is the court that exercises jurisdiction over the property in Bangalore that will have a right to set aside the award. So you would go to Bangalore and say you are the appropriate court of jurisdiction for the purpose of being a court in respect of a domestic matter. So to begin with, the concept of seat was very important when it came to international disputes. It had very limited significance when it came to domestic disputes. Number two, we are in any event not talking about a domestic award in the domestic sense. We are talking about an international arbitral award that is capable of being set aside by Delhi High Court. Obviously, we are presupposing that the award has been rendered in India. To begin with, let me start with India. The concept of seat in domestic arbitrations evolved in the last 2 decades based on considerations of convenience, because if you look at a situation like the one I mentioned in Bangalore, you could go to Bangalore for a Section 11, you could come back to Delhi for having the arbitration, you would go back to Bangalore for setting aside the award, and supposing if it was not a property, but if it was a money decree, then you wanted to execute a decree where the main assets were in Bombay, then you would go to Bombay to execute that money decree. In order to bring about elements of certainty that exist in international disputes to domestic arbitral awards, Indian jurisprudence evolved in a manner where the Supreme Court interpreted the concept of seat in domestic arbitration to mean conferring exclusive jurisdiction on courts in India of that place where the seat was located. So, if you look at the decision of the Supreme Court in Inox, in BGS Soma, in Indus Mobile, the evolution of the jurisprudence is that if parties have designated that the seat of a domestic arbitration will be a particular place, then implied or implicit in that agreement is an agreement that all disputes will go to the court that has jurisdiction over the seat. So the definition of conferring jurisdiction on a civil court under the Arbitration Act evolved to include the seat of arbitration as a component for the purpose of determining jurisdiction. If you look at the Arbitration Act, the definition of the Arbitration Act says court means ordinarily the court that would exercise jurisdiction on the dispute. But by judicial pronouncement, exercising jurisdiction over the dispute was meant to include exercising jurisdiction over the seat as well. And that is the manner convergence of jurisdiction or conferring exclusive jurisdiction on courts relating to the seat evolved in India. Now, obviously, when we talk of, I want you to give some clarity about the concept of seat, because I think it is often misunderstood. It is not a very easy inference to derive. And initially, some of the legal practitioners who, in our country, who do a fair bit of international work, we were initially quite surprised when the concept of seat conferring exclusive jurisdiction on a court over the seat court was introduced in Indian law, because we thought that it we thought that it was philosophically, jurisprudentially, a little bit of a stretch of the envelope. But when you look at the manner in which this evolution of law or jurisprudence has helped, it has brought about a lot of certainty about which court you can go to with respect to awards rendered in a particular seat. So, as I said, while it appears to be at first blush a stretch of what is the written word in the statute, it is the kind of situation where I think courts should have stretched the envelope, and I think it is a good development. Now, coming to the second point, obviously, then it means that in an international arbitral award rendered in Delhi, with respect to a property which is situated in Bangalore, and some property in Singapore, and some property in Argentina, the court that would exercise jurisdiction would obviously be Delhi High Court, because the parties have designated Delhi High Court as a place of jurisdiction. It would also be the same situation if it's a domestic award and the property is only situated in Bangalore and there is no international component. The Delhi High Court would exercise jurisdiction to set aside that award. An international arbitral award, for all practical purposes, if it is rendered in Part 1 in domestic jurisdiction, the connotations are the same. It is treated broadly like a domestic award, barring rare exceptions. What happens if the Delhi High Court sets aside that award, and what is the impact on jurisdiction of the arbitral tribunal? Can there be a new arbitration? What is the impact on the jurisdiction of the arbitral tribunal? What is the effect of setting aside? What is the effect on the seat of the new arbitration? These are issues that some of the issues that have become a little controversial in light of the development of jurisprudence. Some jurisprudence, some of it is coming out of Delhi High Court. Ordinarily, when you set aside an award, the award is annulled. As a first principle, the award is extinguished, and you can go back and start a new arbitration. So I have an arbitration clause with Mr. X with respect to a property in Bangalore. The seat is designated Delhi. The award says that Mr. X is directed to the contract is specifically enforced. He has to sell it to me because we had an agreement to sell. Delhi High Court says that the award is devoid of any reasoning at all. There is no evidence, nothing at all. It is completely perverse, and the award is set aside. Ordinarily, if I want specific enforcement, I could still invoke the arbitration afresh. If I then need to file a Section 11 application, if I then need to seek an appointment of an arbitrator, I can do that, and the arbitration will start afresh. But there are certain grounds of setting aside an arbitral award that will attain finality, and I think some of those grounds are often not discussed. So if you look at, for example, Section 34(2)(a), subclause 2, one of the grounds of setting aside an arbitration award would be that the arbitration agreement is not valid under law to which the parties have subjected themselves, or the law that ordinarily governs the arbitration agreement. So if the arbitration agreement itself is invalid and the award is set aside on the basis that the arbitration agreement was invalid, then you cannot restart an arbitration. There is finality associated with that setting aside. Although the arbitral award is annulled, but at the stage of annulment, there is a binding decision of the Section 34 court that there exists no arbitration agreement between the parties. So you obviously cannot start an arbitration case. Similarly, if you look at subclause 4, where the arbitral award deals with a dispute not contemplated or not falling within the terms of submission to arbitration, or it contains decisions beyond the matters which are the scope of the submission. Those of you who have done some arbitration would know that there is a concept of accepted matters. So we write an arbitration agreement, we say all contractual disputes between the parties will go to arbitration, except issue number X will not go to arbitration. The arbitrators render an award in which they decide all contractual disputes, but they also give a decision on issue number X. There is an evolving jurisprudence in India, and there is no clarity whether an award can be set aside partially, severally. But let us not go in that area. Let us assume that the court sets aside the entire award, saying that the arbitral tribunal has decided an accepted matter. To the extent the accepted matter has been decided by the arbitral tribunal and the court has given a finding that it is an accepted matter, it could not have gone to arbitration. There can be no arbitration of the accepted matter as well. It can't be arbitrated again. I can think of one more exception. Arbitrability. Mr. X and Mr. Y decide that they will arbitrate. Mr. X and Miss Y decide that they will arbitrate whether they should be granted a divorce. And the arbitrator grants a divorce to them, and the award is challenged. And the award is set aside saying that this is opposed to public policy, this is not an arbitrable matter. If that award is set aside, even if you have a written arbitration agreement, you cannot go back and arbitrate again. So while there is a general principle that if the Delhi High Court sets aside an international arbitral award, on the matter of arbitrability, the jurisdiction of the arbitrator might be restricted in certain situations, even if you re-arbitrate the disputes, to the extent the award is set aside on certain limited grounds that are given under Section 34 of the Act. This is, of course, subject to the broad principle that as a general principle, if the arbitral agreement survives, that survives. If some of the disputes which are arbitrable in nature survive, then that survives. Non-accepted matters are capable of surviving, and matters that can in any event be submitted to arbitration are capable of surviving. So I just wanted to clarify that while as a broad principle an annulled award does not prevent re-arbitration, it will prevent re-arbitration on certain issues. As a matter of practice, any finding given in an annulled award will be of no consequence. As a matter of law, it will be of no consequence. But as a matter of practice, sometimes the nature that was led, the nature of evidence that was led in an earlier arbitration might impact an arbitrator's mind in the subsequent arbitration. So for example, if in an earlier arbitration, one of the claimants made a statement that is XYZ, and in the second arbitration, after the first award is annulled, he makes a statement ABC, which is completely contrary to X, Y, and Z. It is possible that the arbitrator may not see that I will bind you down to that statement, but there will be some minor shadow of the conduct of a party in the earlier arbitration that has been set aside in the second arbitration. Now that is not one cannot make an objective statement as to how much it will impact. It is a subjective statement. Some arbitrators might be impacted, some arbitrators will close their eyes and not be impacted. But as a matter of law, barring a few rare exceptional situations, you will be able to re-arbitrate the issue. So that is the manner in which jurisdiction of the arbitral tribunal will be impacted if you re-arbitrate an issue after an international arbitral award is set aside by the Delhi High Court. Let us now come to the issue of seat. How will the seat be impacted? To the extent the arbitration agreement has not been set aside or not been held to be invalid, an agreement with respect to seat will survive. So if the arbitration agreement survives a Section 34 challenge or a challenge to the award, the seat determination will survive. You will be bound by that same seat. But there is again jurisprudence in India that thereafter it is open for the parties to redesignate a seat. So there is an arbitration agreement in which Delhi is the seat. Delhi High Court has set aside the award, not on the ground that the arbitration agreement is invalid, but on some other ground. You will be bound by the determination that Delhi High Court, that Delhi is the seat. But if you want, both parties can agree to redesignate the seat and decide to go to Bombay. There is nothing that prevents parties to redesignate a seat by consent at a later stage. So if that will be, as I said, seat will not be impacted except by agreement when it comes to redesignation of a seat post setting aside of the award. There is a very interesting, as I said, I thought that the development of Indian law, when it designates, even for domestic arbitrations, when it observes that seats are exclusive jurisdiction clauses or confer exclusive jurisdiction on courts, I think the development was very good in the context of bringing about certainty regarding which courts you can go to. But there are certain minor problems, interpretational issues with respect to this principle that we are seeing emerge in Indian courts. So broadly, the overwhelming jurisprudence is that when you read an arbitration clause and there is a clear designation of a seat, then even if there is an observation regarding conferring of jurisdiction of courts which are different from the seat, then in case of conflict, Indian courts have generally tried to interpret the contract in a manner that allows the seat courts to exercise jurisdiction. So for example, if there is a clause that says courts in Delhi will have jurisdiction, and then later the clause says that the seat will be Bombay, courts have relied upon two broad principles for the purpose of generally finding that it will still be courts in Bombay that will exercise jurisdiction. One principle is that there is no conflict at all. Courts have observed there is no conflict at all. The designation of courts in Bombay is only if you file a suit. But if you go to arbitration, it is very clear you've designated Bombay as the seat courts will exercise jurisdiction. So one principle is no conflict, and the other principle is in the case of minor conflict, it is the designation in favor of the seat court that will prevail. So the general tendency of Indian courts is that it is the seat court that will exercise jurisdiction for the purpose of setting aside awards. In a decision of the Supreme Court in Mankastu, it's a 2020 decision of the Supreme Court. While dealing with an international arbitration, certain observations were made where the Supreme Court of India appeared to recognize a distinction between court proceedings for enforcement of an award and setting aside an award in an international arbitration, and proceedings for the purpose of constitution of a tribunal under Section 11. That jurisprudence was sui generis in the sense that the seat was Hong Kong. The award rendered in Hong Kong would have been set aside in Hong Kong. But the parties had also said that Part 1 of the Arbitration Act will apply. So they had come to the Supreme Court to seek appointment of an arbitrator under Section 11. And the Supreme Court recognized a possibility where in certain situations, only for the purpose of appointment of an arbitrator, you may be able to come to in India, you may be able to come to India, which is not the seat court, for the purpose of constitution of an arbitrator. Flowing from that decision, there are 2 or 3 decisions that have come out from Delhi High Court, Cars 24 and Hunch Circle, where in the case of conflict, the court has attempted to divide the decision or the agreement amongst the parties as to which matters will go to the seat court and which matters will go to the courts that have ordinary jurisdiction. I don't want to go into the details of that case, but in those cases, but if you read those cases, inherent in the analysis of those cases is this tension between the original concept where courts in India under the Arbitration and Conciliation Act were always meant to be courts that exercise jurisdiction over the dispute under Indian law, and it was not really intended that seat courts necessarily will always be exclusive jurisdiction courts, and then the parallel concept of the Supreme Court having decided that seat courts are exclusive determination of jurisdiction. Personally, I think that if as a matter of policy, if the correct principle is that you should recognize determination of seats as giving exclusive jurisdiction to courts that have jurisdiction over the seat, then these ancillary principles of trying to distinguish between parties' agreement that some disputes may not go to seat courts is not a good idea, because the principle itself of recognizing the concept of seat in domestic arbitration is a principle that is fragile or will have limitations, and if it has to be applied, it should always be applied uniformly. So my answer to the question then is, the effect of setting aside of an international arbitral award by Delhi High Court on jurisdiction would only be that parties will be able to arbitrate on all issues again, except on those matters that impact the jurisdiction of the arbitral tribunal, setting aside of the arbitral award because there is no arbitration agreement, setting aside of the arbitral award because the matter was beyond the submission to arbitration, and setting aside of the arbitral award that the dispute is incapable of arbitration. But on the issue of seat, there will be no impact of setting aside until and unless the parties by consent decide to redesignate the seat in the second arbitration. I think that's all that I have to say, but if you have any questions, I'm very happy to answer. Yeah.
I'm only confused about the seat and venue now for the reason that you said that domestic awards, so the exclusive jurisdiction of the courts will be at the seat. So when we say that, is it only to do with the appeal or the challenge, or even the arbitral tribunal will be located at the seat?
So in broad principle, seat is the legal determination of the parties for the purpose of where the arbitral tribunal will be deemed to be sitting as a matter of law. Venue can be any place. So you can always say seat Delhi, venue Bombay. Then the seat will remain Delhi, everything will be associated with Delhi. You can say seat Delhi and not say anything about venue, and irrespective of wherever you hold the arbitration, it will deem to have been held in Delhi. The only thing of significance is that in the absence of a clear determination of seat and in the absence of a clear determination of a seat, but presence of a clear determination of venue. So for example, if parties do not determine a seat in the contract, but say that the venue of the arbitration will be Delhi, then courts have generally said that that is enough for the purpose of determining seat also. But other than that, as a matter of practice, venue is of a very little legal consequence. It is the contract to determine a seat that confers jurisdiction on courts.
So when the contract or agreement says that the jurisdiction of the courts of Delhi, it does not say courts of Delhi, but it says jurisdiction is of New Delhi. Do we consider that both seat and venue is at New Delhi?
Now, the question that you're putting is very interesting. These are matters of construction. So you are talking about a situation where a contract does not expressly determine the seat, but says other things. For example, it can say the venue will be Delhi, or it does not say that also. It says that for all arbitration proceedings, it will be the courts in Delhi that will exercise jurisdiction. Now, this is a matter of construction of the arbitration clause. Broadly speaking, generally Indian courts will say, let us interpret the arbitration clause in a manner that we will say that the parties have determined a seat. So if the arbitration clause says nothing about venue, nothing about seat, but says all proceedings associated with arbitration will be in Delhi, you will find judgments that say that that is the determination of the seat. That they have decided that the seat will be Delhi.
And if a party wants to take a contrary view and say that it is only talking about jurisdiction as Delhi, but since cause of action is in Bombay, I want to proceed there.
So as I said, that is why the principle of BGS Soma, where in domestic arbitrations we have said that seat gives exclusive jurisdiction to the courts over the seat, has its limitations. And it is capable of being implemented across the board only if you recognize this overwhelming public policy of finding in favor of a seat and not allowing contradictory interpretations to prevail. Because if you allow contradictory interpretations or part of jurisdictions to be divided, then the very purpose of this judicial precedent or this evolution of policy in arbitration law will be defeated. It won't get us anywhere. So if you really have to follow the principle that seats give exclusive jurisdiction to courts, I think, except in rare situations, I can't imagine them. You should always, courts should always be in favor of finding where the seat is, and that is where the courts will be associated.
So when we talk about the jurisdiction of a court with seat to set aside an award, does section 48 in a way contradict to that principle when an enforcement court, while considering the grounds under 48 to decide if the arbitral award should be set aside, being a jurisdictional court because of the property being situated there, takes the role of a seat court and sets aside that award?
Wouldn't 48 apply to only a foreign award? Not
That's what I'm saying. In a case of foreign award as well. if
the
we're talking
remedy,
about
I think the Contract Act recognizes a different method of remedy. As I said, if you look at section 2, subsection 7, all awards rendered under part 1, even if they are awards with respect to an international commercial arbitration, are designated as domestic awards. And the policy of the Arbitration Act is that for domestic awards, you have two-pronged layer of scrutiny. You can interfere at the stage of setting aside, and you can interfere at the stage of enforcement. Whereas all awards that are foreign awards, which are not rendered in India, will only be subjected to one scrutiny. You will not touch the validity of the award, but you will only deal with the enforceability of that award in India. Because the same award, if it is with respect to a part of the property in another jurisdiction, that country may allow its enforcement. So you will only deal with whether it is enforceable in India or not. That's all. And
it also touches on the validity part in some respects.
yeah, but it doesn't. It comments on validity without allowing you to set aside that award. So your determination on saying that this contract is invalid as a matter of Indian law will only impact its enforceability in India, will not impact its binding nature as an award in other jurisdictions. There are several cases, particularly arising out of France, which is very, very advanced in terms of civil law countries in Europe have taken arbitration to a different level because of the manner in which commercial law has evolved in those countries. There are several instances, as I said, without going into permutations and combinations, where a particular award has been held to be unenforceable in one country, has been enforced in others. There are, in fact, even awards that have been held to be unenforceable because the country that held it to be unenforceable said that under the substantive law of that country, so let's say an award that is governed by Indian law but is rendered in Paris, you bring it to India and the Delhi High Court says, I'm not going to enforce it because this award is invalid under Indian law. So, but this determination is only for the purpose of enforcement. You take that award back to Paris and they will enforce it as well. No, they will. If the assets are in Paris. Yeah, if the assets are in Paris, they will enforce it.
There is a practice of declaring the award to be invalid under section 9 or 10, under 9 in India, that is before 12. People are going to try code and saying that declared this to be an invalid award.
That is contrary to the limited interface.
Practice that is required.
I think that problem started with Sukanya Holdings. You could bring a additional cause of action and then say civil courts have jurisdiction. I wish we had clearer jurisprudence on that, but it's not a good practice. It's not a good practice. I know of instances where in international arbitration, if a party has gone to a civil court in India and tried to seek that the arbitral award or the arbitral proceeding should be declared as invalid, the International Arbitral Tribunal has held that party to be in breach of its obligation to arbitrate and has imposed exemplary costs at the time of making an award.
But again, enforcement of that cost will be.
Yeah. In India, it will be an issue, but in several other jurisdictions, it won't be an issue. Yes, ma'am.
I had a question also. Actually, it's not much of a question though. This relates to part 1, that is the domestic awards. Now, there was this judgment by the Supreme Court rendered sometime around 18 or 19, 2018 or 19 on Sundaram Finance, which diluted the issue of the seat, saying that the award creditor can go wherever the assets are located. So do you see this trend, because now all the courts, all the high courts, Delhi High Court included, are following this judgment. Don't you see that as a dilution of the sole jurisdiction given to the seat court? Because for instance...
It is, I agree with you entirely. I agree with you entirely. If I understand your question, what you are saying is that if you had
keeping up to the time. So we'll take benefit of the presence of Apurva and Gaurav, because I don't know whether Gaurav will have so many other commitments thereafter. Let's have a group photo before they leave. So all of us, please come up, and we'll have a group photo before the lunch. Right?
कैमरा तेरे हाथ में बैठे कैमरा थोड़ा ठीक
Bobby, we'll take the advantage of your presence.
इधर सेंटर में इधर 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 नहीं आ रहा आगे बिठा दिया
Or yeah, you can have one row people, you know, but then people who sit down there, then you will not.
One can sit, one can stand.
Some tall people can sit, then some others. So they can be seen in the camera. Some of you
कैसे करें यार उधर सीटें क्यों लगवा दी यहाँ पे हाँ ठीक है सर ठीक है
Some of you can sit and
बैठ गई फिर बैठ पूरा आ गया हाँ
Some youngsters, please come this side. Come in.
Yes, sir. पूरा आ गया पूरी आ रही है ले ले पूरा आ रहा ना पीछे से ले ले थोड़ा पीछे आ जा थोड़ा और पीछे ले ले पीछे से ले थोड़ा
Yes, sir.
Yes, sir. ओले 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 चेक कर लो आ रही ठीक आ रही देख ले एक मिनट रोक 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 रोक
Thank you.
मैंने सारा थैंक यू जल्दी बोल रहे
I request again, you have a very interesting session after lunch, so please be back on time. You are, you are going right now on time, so let's be back on time. Yeah.
Professor Akansha Singh and Mr. H.S. Professor Akansha Singh is a legal professional and academician whose exemplary contributions in the field of law embody both intellectual depth and unwavering dedication. Ms. Singh is an alumna of Guru Gobind Singh Indraprastha University, holding a BA LLB honors. She further honed her legal expertise with Masters of Law in Business School from National Law School of India, University of Bangalore. She is also an esteemed UGC NET qualified scholar, reflecting her commitment to academic excellence. Besides all this, she is a research fellow with Ministry of Law and Justice, Government of India. She has showcased her ability and influence critical area of lawmaking, including the required amendments in Arbitration and Conciliation Act 1996. Her expertise has been sought for lectures and participating in high-level discussions with professionals. Currently, she inspires the next generation of legal minds as a mentor for prestigious JSEP course at Lifelong. And for the last session, we also have Mr. H.S. We fondly call him Bobby Chandiok. So Mr. Bobby Chandiok is a stalwart in the field of commercial litigation and arbitration. With a career spanning over more than 3 decades, Mr. Chandiok is widely celebrated for his unparalleled expertise, strategic foresight, and deep understanding of complex legal and commercial issues. His practice encompasses a broad spectrum including infrastructure, banking, pharmaceuticals, telecom, media, entertainment, and high-value multifaceted legal challenges. Mr. Chandiok's career epitomizes the highest standards of legal professionalism, intellectual rigor, and steadfast commitment to justice. His ability to take a 360-degree view of legal issues and deliver comprehensive solutions places him in the upper echelon of legal profession. Over to your conscience to take this. Yes. He's related to Mr. Amajit Singh.
I think I was add to that.
Yes.
So this is something. I'm sorry, I'm taking away 2 minutes from the lecture, and my apologies to Akansha.
No, you will take 5.
So this is, I spent the whole of my schooling and my college carrying the surname Chandok, and everybody asking me, Chandok kya hai? Never heard of this name. I joined the profession, and suddenly I'm the most popular guy around. And my first ever appearance before a metropolitan magistrate was, are you related to Mr. Chandok? The first question that the judge ever asked me. And my answer was, if it matters, yes. and honestly, I had heard of him, of course. We had seen him in court, but I had never interacted with him. And then began a series of interactions as the universe, as they say, and which has, for the last 3 decades now, he's been my guide, my mentor, everything that you can think of, and I think he delivers more on the table than any senior that I've seen. Thank you.
Thank you, Sarika ma'am, for such generous introduction, and Chandok sir for setting the background here. Not with respect to the topic, but to enlighten everybody that we are going to start our new session that is on the topic. If we can show the screen. Yes. So far, we've been discussing about section 34 in context of challenging the award. Now we'll be discussing about remission of the award. So how many law students, again sir will say everybody is a law student, but law students from colleges are there. Okay, that word I will identify. Alright. So have you heard of section 34(4)? Yes? Okay. So To start with the basics of it, we allow that while you are challenging an arbitral award, at the same time there is an alternative remedy, often less invoked remedy, that is of section 34(4). So I would urge all of you to refer to your Bare Act for the provision. And in addition to that, I have also mentioned it over here. Okay? So we'll discuss this, but before that, let me just take you through a few questions. The first one, can we set aside and remand the matter simultaneously, okay, or the arbitral award simultaneously? I've used the term, I've taken the liberty of using the term remand here, but can we remit the award as well as set it aside at the same time? First question. Can the court suo moto remit the matter? Does the court has the power to suo moto do it? Thirdly, what are the mischief that really falls which can be cured under section 34(4). Okay, so we'll be discussing this. In context of this question, let's now read the provision. So if you read it, on receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party. Okay, so you stop at certain places. The court may. So now coming to the question whether the court has discretionary power to remit the matter or not. And if it has the discretionary power, can it do it suo moto or will it require the application from the party? So we move to the next part of it, where it is appropriate and it is so requested by a party. So from the bare text, reading of the bare text, we understand that two essentials or two questions have been answered from the bare text. Adjourn the proceeding, okay? So can you set it aside at the same time when you are remitting the award? So it says adjourn the proceedings. For a period of time determined by it, in order to give the AT an opportunity to resume the arbitral proceeding. The opportunity is with respect to resumption of the arbitration proceeding. So will it be a continuation of the same award if at all the AT now makes some changes, or will it be an additional award? Have you ever heard of the term additional award? Anybody?
Yes, we have.
Yes. So you have. This is for the students. Yes. Anybody has heard of the term additional award? Okay, so the student from law colleges. So yes, have you ever heard of the term additional award? You can refer to section 33(4) with me. We'll do a comparison also of the same, okay? That how is this different from 34(4). So whether this is with regard to the continuation of the same award or not, or to take such other action. Now do you see, or to take such other action? No embargo or no enlisting of what action is to be taken by the AT. So can we construe from the reading of this much of the provision that there is wide power that has been given to the AT, okay? Or to take such other action as in the opinion of the AT will eliminate the ground for setting aside the arbitral award. The most crucial part of this particular provision which says in the opinion of the arbitral tribunal will eliminate the ground for setting aside of the award. So if the AT feels that I can set aside, this entire award will not be have to set aside provided I do some curial changes in this particular award. So now let me ask you from the first session the question that what all grounds are there under section 34(2)? Can you recall any of the grounds? Incapacity we discussed at great length, yes? It is against public policy. Okay, very good. Patent illegality of the award, if you can see. Yes. So all these grounds are there. Is the arbitral tribunal now supposed to cure these defects which are enlisted under section 32(2), or is it something else? Or do we have to come and find out that it will be done on new grounds? So are you getting the question? The AT's power, because it is not so enlisted here, comes to a point of our discussion here that what all grounds can be actually referred by the AT for which a remission can be done and on the basis of which the AT can actually make the changes or make good of the award. Is this much so far clear to everybody? Okay. Now the pro and con of going last in the session is that either everybody would be sleeping or you all will be very awake, energized with the food that you all had. So I need your attention and I need your interaction also, okay? So now coming to the first question, you just have to say yes or no. Can we set aside and remand the matter simultaneously from the reading of the provision?
No.
How many yes? Okay, how many no? Okay, very good. Then we go to the next question. Can the court suo motu remedy the matter?
No.
No. Very good. Why so, sir, if you may say? Upon application, yes, very good. What are the mischief? This is the last leg, right, that I was discussing about. That what all should be the ground for the court to understand that, okay, this is the time I should remit the order back to the 80 for it to be cured, or I should rather be setting aside. Which one do you think, which all grounds from section 32 can be claimed? Just from your bare understanding of section 32 subsection 2 grounds. Do you think anything in your mind that, okay, this is something for which a revision can be done and it can be cured by an AG? Okay, if the jurisdiction has been exceeded, yes. And can it be on the ground of when there is immorality or public policy? Yes. Can it be so? So this is the grey area, right, that we are discussing this today, that what all should be enlisted here and how do we really proceed it. So by the end of my discussion, you can pick either of the sides, but I'll be going and I'll be discussing both. Now what is happening here is that all the judgments that I've referred, either I talk about the Dyna Technologies case, iPay clearing services, Chandok sir will be discussing about the facts and the judgment, but I've just taken the important essential part from the judgment in context of my discussion. It says evident fallacies cannot be rectified as this would require the tribunal to revisit the conclusion. So they are basically hinting and telling you that you should not be getting into the finding of the award. Okay, do you understand the difference between finding and reason? Finding and reason? Anybody?
Finding is a conclusion and the reasoning is the reasons you reach that conclusion.
Yes. So, do you think if you have missed on a finding in a particular matter, can it be remitted and then be cured? Will it be good to do so? That you have missed on a finding itself? No? Or if you have concluded on something, but you have not given a reasoning for that, which one do you think looks more better or sounds better to us for the 80 to deal with in the stage of remission? The second one? Yes. Okay. So, that is what they have said in this particular judgment also, that you do not get into the evident fallacies. Now moving ahead, in the recent case, that is NHI versus Trichy Expressway, if an award is found to suffer from any illegalities of section 34(2)(a), what are those grounds? I hope you all can recall. It must be set aside, okay, emphasis on must, and cannot be saved by section 34(4). So 34(4) is remission, and they have highlighted and they have told in the judgment that you must not send it for remission if at all it falls in any of the category. But if this is so, what is the point of discussion and why is this entire discussion happening? So there must be some grounds. Now if you go to Ashish sir's lecture, he spoke about incapacity, and he said that if in a given situation you were not able to present your case, or you were not furnished with the document that has been relied on by the AT, can that be considered as incapacity? Yes. And can that also be a ground of remission, that you go back? What do you think is the idea or objective of Arbitration Act? Is it for the arbitral award to be set aside, or is it for it to be cured and then to be upheld? Yes. So accordingly, keeping the objective in mind, we have to see each ground. And in context of the discussion of this particular section 34(4), if you refer to the term itself, okay? Now let's try to understand, go back to 34(4). So it says to eliminate the grounds of setting aside the arbitral award. What are the grounds for setting aside arbitral award? The grounds that are mentioned for which you are actually reaching to the court by way of section 34(1) and invoking the grounds as per section 34(2). So will it not be redundant to say that you cannot actually take all these grounds and challenge them in the stage of remission as well? So that is why the confusion begins. Now I've highlighted that these judgments that have been given, are they really artificial or not? So let's read the chronology of it. An application is made by the party for setting aside the award under section 34(1), right? Okay. That is how you can invoke 34(4). First, you have to reach to the court by way of 34(1) application. Such application must relate to one or more grounds that are so mentioned under 34(2)(a) or b. Now the third part. An application under 34(4) will be filed within the same settings aside proceedings, and this too will have have to relate with any of the grounds that are so mentioned. Why? Because of the term that we read here. Because it says the 80 is supposed to eliminate the grounds for setting aside. So this is one interpretation. Have you heard of purposive rule of interpretation? Yes? So the question that I just asked you, that what do we really expect from the Arbitration Act? Do we want upholding of the award, or do we want more of set aside of the award? If at all it can be cured, we would want it to be cured. So that is why using that purposive rule of construction also we can say that we must allow the remission to be done in the grounds that are, for the grounds that are so mentioned under 34(2). So now going back to this, if you refer to most of the judgments, okay, I have not laid down the judgments here, so I would be dealing with it. If you refer to these judgments, you will find out that what are the grounds for which remission has been done. Have you ever referred to any judgment here? Anybody? If there is no reasoning or there is gap in reasoning, the court will remit it to the 80, okay? Or if you have assessed your damages, or if there was a case wherein the document was not furnished and the finding has been given, they say that, okay, provide the document also to the party. So all these have been dealt with by the case, but in a very constructive and narrow manner. So that takes us to the old law, 1940 law, which also spoke about and which also had the power of remission to be done by the 80. So I'll just do a comparison of the old law and the new law for you to understand what is the intention of the legislature for framing 34(4) in this particular manner. Why do we need to know the intention of legislature? Anybody? Why do we need to know the intention of the legislature? Yes. Are we supposed to stick to that particular intention? Yes. Are we supposed to stick to that intention? Yes, that is why we deal with all these rules of interpretation. Yes. So, if you refer to this, there have been so many cases, right? We talk about the old law, wherein they have highlighted section 16 of the old law. So, I'll just take you to section 16. Okay, let's read the title. Power to remit award. The court may from time to time remit the award or any matter referred to the arbitration. The court may remit or any matter referred to arbitration for reconsideration upon such terms as it thinks fit. And what are the terms written here? Do you see these terms written in section 34(4)? We don't see these terms, right? So there were terms like where the award has left undetermined any of the matter referred to the arbitration or where it determines any matter not referred to the arbitration. कहीं देखा है ये? Yes? Nowhere? So we have not covered the class then, the first section. Okay, where the award is so indefinite as to be incapable of execution. Okay, and the third one, where an objection to the legality of the award is apparent upon the face of it. ये देखा है? Yes, you can recall of this. So these were the grounds that were present in the 1940 law, but we have intentionally taken it away, maybe with the reason that we do not want remission to be done for these grounds. That could be one understanding and interpretation if you compare it and if you relate it with the 1940 law. But at the same time, I will also ask you to refer to the previous law with respect to the power of the court. Now, the first discussion that we had was whether a challenge should be accepted or not, whether it can be modification or varying or not. If you have done a comparison of the old law and the new law, you will find that we have shifted, right? So, likewise, in this context, with respect to remission also, you will see that there has been a shift with regards to the grounds that have been laid for remission, which is not so there in the present law. Okay, now let's refer to section 33, subsection 4. All of us, please. Section 33, subsection 4. If you read it, do you see it is something very similar to 34(4)? Unless otherwise agreed by the parties, a party with notice to the other party, okay, a party with notice to the other party may request within 30 days from the receipt of the arbitral award, the arbitral tribunal to make an additional arbitral award. So as to the claims presented in the arbitral proceeding but omitted from the arbitral award. Do you see any distinction between 33 and 34? Or do you think these are all similar grounds?
They're different because here we're only going for the part which is not being dealt with the arbitral award. 34(4), you're going for
omitted, let's say the reasoning has been omitted, can it not be invoked by 34.4? Okay, any other difference that you can think of? 33.4 and 34.4?
34 is when we go for setting aside.
Very good. So 34.
That is how we reach the code first, and then we have to make the application under 34.4 for the remission. So that is the basic difference.
So which one comes first, 33 or 34?
33.
Right. Yes. So as pointed out, your name, sir? Keshav. So as Keshav has pointed out, that for invoking 34.4, what all do you need? Firstly, there must be an application under section 34.1, which is not required under 33.4. Okay, what else? Can it be done suo motu by the court, by the AT? Yes, it will not be. If you read it later, try to read the comparative perspective also. You will find that it is not so under section 34.4, but it is so allowed under 33.4, right? Then what is this confusion? If we are so clear about it, why have the courts tried to conflate and say that both are similar or both are to be considered similar? Okay, so I have written here, the high courts have tried to conflate the scope of 33 and 34.4. How have they done that? They have said that it is to extend the 30-day time period in section 33. So if you read the time period also that is mentioned, after 33 is done, you could not invoke 33. Maybe you can go and invoke it under section 34.4, right? You can ask for a curability under section 34.4, provided that if the time has lapsed for section 33. So the court has said that it can be one way that both are similar because it extends the 30-day time period in section 33 to the longer timeline under section 34. Okay. Secondly, to allow the parties to approach another forum, that is the court, the section 34, the court to make same request with respect to correction interpretation. Also, I missed on this. If you refer to the title of section 33, does it very clearly tells you what is the ambit of section 33's power? It says with regards to correction and interpretation of the awards. So is this narrow or 34 narrow in nature? If you have to compare. Okay. Only with respect. Okay. 34.4 is more narrow or 33 is more narrow? We all had good lunch and we are done.
34 is more narrow, it is specific to 35.
Okay. Yes, so 33 is very clearly mentioning and telling you that it can be with respect to interpretation of an award, right? Any lacuna that is so there and you need an interpretation of it, you can invoke the remedy of 33. But for 34.4, you must first exercise that the application has to be filed under 34.1, okay? So this discussion with respect to similarity of both has been done by the High Court. But let me tell you what is my stand. In interpreting the legislation, each provision thereof should be given effect. And the two provisions do not exist for the same purpose and cannot be interpreted as to render one of them redundant. Can we say that okay, 33 and 34 are same and therefore you can invoke either of it? Do you think the legislation will have two provisions stating the same thing? No. So definitely there is a distinction that we have concluded and discussed, which is so there with 33 and 34. So 34 to conclude, 34.4 extends to curative measures contained in 33 to render an award on a claim which has been overlooked under 33.4. So if it has been overlooked, you still have the remedy and to invoke the jurisdiction under 34.4. Now, how much time do I have to this? 15 time. Okay. So, okay. Going back to our other discussion.
Till 4:15.
Yes. Okay. So, do we have any statutory provision? Do you remember the discussion that I did? That 34.2 grounds should be allowed for the remission process. This is one set of thought, okay? That you can invoke remission for all the grounds that are so mentioned under 34.2. If the court thinks that it is something which is curable, let's say with respect to incapacity, can they do so? Yes. But let's say it's with respect to public policy. An arbitrator who has given you an award which is not right, which is illegal on the face of it, which is against the public policy, do you think it will be fine to remit the award to the same arbitrator? No? That's what we think, right? It should not be. Okay. Then the question comes that if in in that situation you do not want to remit the arbitrator to that, remit the award to that arbitrator, how will you appoint a new arbitrator? Is there any process given for that? Yes? How will we appoint a new arbitrator at the stage of remission? If allowed, and if I want to say that this is against public policy, the award that has been given, and it should be allowed to be remitted. Okay? So, who is that particular arbitrator going to be, and what is the procedure for his appointment? Will we invoke the principle, okay, the principle, not the provision, the principle so mentioned under 29A subsection 6, refer to 29A subsection 6. Can we take the essence and principle from here? What does it say? It says, while extending the period referred, it shall be open to the court to substitute one or all of the arbitrators. And if one or all of the arbitrators are substituted, now the important point, the arbitral proceedings shall continue from the stage already reached and on the basis of the evidence and material already that are on record. So, do you think it will be just that if at all we have to appoint a new arbitrator at this stage, will it be just to follow this particular principle? Just a question that I am leaving you with for you to think on. Okay. So, coming to these statutory remedies, okay. Does the statute put an embargo? You have read 34(4) with me. Do you think statute put any embargo on the working of the AT? Yes? No embargo at all, right? We see that in his opinion. Now go back to 34(4). It says, in his opinion, if he thinks that it will be remedying the ground for setting aside of award. So this is a very wide discretion that we have granted, and we have compared it also with the old law, wherein we understand that there is nothing that bars that particular AT from exercising discretion and actually setting aside. But then the con of it comes that will it not be a negative way of providing arbitrary discretion to the AT? It can be, right? The scope of criticism of it can be that you are providing a very big power or discretionary power to the AT by not putting any of the grounds under section 34(4). So that is why the language of the statute does not suggest that the tribunal is barred from revisiting its finding, which was said in the initial judgment that I showed you, right? Dynamic Technologies, wherein it said that you can't get into the findings again, but here the language of the provision does not bar us. And that is why the arbitral tribunal has some discretion. Can anyone tell me how is the arbitral tribunal having some discretion from reading of 34(4)? How do we say AT has discretion? As in the opinion of the AT. Yes. This is telling us that whatever he thinks, obviously it has to be backed by reasoning, but whatever he feels will be the right ground for curing that particular ground of set aside. Okay. Then the two interpretation of this entire provision wherein we are allowing a revision to be done. Do you think this is actually in favor of the Arbitration Act, or do you think it is something that should not be there, or should be more restrictive or more wider in nature? Yes, okay, so you can read from the PPT as we were doing it with Apurva ma'am. The true interpretation of section 34(4) is in line with the principle of minimal judicial intervention, right? How minimal judicial intervention? Okay, you are actually reading the PPT. How minimal judicial intervention is being promoted when you allow remission? Yes, because you are saying the court is not setting aside, the court is suspending the matter and giving another opportunity to the AT, and that is how minimal judicial intervention, and which is the idea of Arbitration Act, right? So, M. was dealt by with Akash sir. Like he said, therein we accepted and we concluded that the award should not be modified. But does it also cover that the award should not be modified by the AT? That is the grey area, right? That award should not be modified or varied by the court. But what about the AT? Should it also not be modified or varied by the AT, or should it be otherwise? So constructively, if we read, section 34(4) is based on the same scheme of section 34, and likewise thereby we can conclude that maybe it should not be allowed to be done by the AT also, as they were answering as Nupur, right? Yes. As Nupur was saying that it should not be allowed on broader grounds and rather only for restrictive manner. Okay, far. What do you think will be the possible misuse if we allow all the grounds under 32(2)? Is there any possible misuse that can happen? If you are a party, you got an award in your favor. The other party has challenged it. Okay? What is the possible misuse that can be done by either of the party? Delay, exactly. Now you have extra time to file an application for 34(4) for it to be dealt with, and again for it to be considered throughout that period of time. You have time to enjoy, right? So that is why we say that 34(4) can have possible misuse also. That is why we expect that there must be some clear guidelines with regards to what should be dealt with under section 34(4), what all grounds should be applied, and whether the discretionary power of the AT needs to be more restrictive or not. So as rightly answered, there will be delay in the enforcement of the award, and that can be a possible misuse. Okay. Now the conclusion here would be that even though we allow the AT to do this, okay, let's understand. I have allowed the AT, I have remitted the matter and the court, I have remitted the matter to the AT. And the AT has now taken up and discussed whether negative, positively, whatever changes he has made. Do you think there is still something that is protecting us, this particular award, or the parties that are interested in the award? Is there still something? Is there any other option that the court still has? Now the AT will submit the award back to the court. And can the court still exercise the option of setting aside the award? It can do so. So, in totality, we can say that the court still has the power, if at all it feels that the AT has. This has happened also in the recent case of All India Radio, wherein the court concluded that even though after remission the AT has not cured, has not provided the reasoning, and therefore we will not allow this particular. Okay. Now, when I say particular award, again, going back to my question, is this a continuation of the old award? Can we say supplementary award, or do we say additional award? Is it an additional award? Yes. How many for additional award? Do we call this an additional award now? Okay. Can we call it a supplementary award? Okay. Additional award we read 33(4) is under 33(4), but have we used that term under 34(4)? No. So can we say that it is a supplement? So in one of the judgment also the court has said that it will be considered as that this has to merge with the original award, and accordingly it will be so considered. Okay. Now coming to this question I have already put to you. Should we allow remission of an award which is against public policy? Just a hypothetical question. If yes, do we remit it to the same arbitrator? And if you do so, or if you change the arbitrator, what will be the position? How is it going to be different? If you're changing the arbitrator, how are we going to appoint a new arbitrator at this case? So we need clarity with regards to that as well. I gave you a hint of 29A6, which can be referred, the principle can be used. And now coming to the last part as to how, no, this is not my audience, this is all of us waiting for the Gayatri Balaswamy judgment to come, wherein we are hoping and expecting some more clarity with regards to this particular topic. Thank you all. Over to Sanjay.
Test check. Yeah. So like a good student, I got my father with me. I got a set of judgments also here with me because I don't know what kind of questions I'm going to face. And I'm terribly terrified because I have two of my very revered seniors here sitting in the audience. And I am just, it reminds me of my time in law fac. I had done my graduation in BCom. So I had some knowledge of, say, commercial laws already. I spent 3 years in passing that course. And therefore, the professors who would come in would first say, Mr. Tendok, you will not ask any questions because what we are teaching you, you already studied in college. So therefore, I'm hoping that those principles will apply here because I'm before somebody who knows far more than me for all these matters. Now, so as I said, I have a Farad with me and the Berai. I think we've had a fairly detailed presentation, and thank you so much, Ansha, for setting the plane. And I would want to just probably start with if there are any questions that you have based on the, I would not say theoretical because this was quite practical as well. This was not merely theory. It was also a lot of practical application of this. So if there are any questions on this, perhaps I can mold my presentation, I can mold my, my presentation here to first attempt to answer those queries and then perhaps begin my presentation if it's possible. And if need be, I would then like to, perhaps if the query is in a manner where it requires some discussion beforehand, so I'll do the discussion, answer the query and then inquire. At the same time, like you, I'm a student. I do not know answers to everything. I can rely on some case law, I can rely on what common sense is there, and I can rely on what Supreme Court normally does by utilizing Article 142. Are you aware of Article 142 of the Constitution of India? And this is one case, this is one section, 34(4), where this has been utilized without effectively saying so that we are doing it under 142. But this is Supreme Court of India, they can do it. And we as lawyers will always say it's application of 142. You just heard. Once you set aside the award, you can't remit it. Right? Supreme Court has done it. And I'll just cite those case laws where they have found that there was patent illegality. Just set aside the award and yet said, I am remitting it back to the arbitrator under 34(4). So now, I don't know how, I mean, honestly speaking, we as practicing lawyers then it becomes very difficult to ascertain as to when 34(4) will apply and when it won't apply. And therefore, sometimes we advise our clients, listen, this go through the High Court and ultimately take our relief in the Supreme Court. Because under 142, they will grant it, High Court will be constrained by what 34(4) says and what the law says. Supreme Court is not bound by that. So therefore, they can do it. So this is the practical side of it. And as I said, I'm supposed to give you a talk on the practical side of it, not the theory part. And this is the practical reality of all of this. Now, so first of all on the questions. Any questions that you have? And please, there's no embargo.
My first question.
But sir, first you must remember, sir, it has been about 45 minutes since lunch. Food is fermenting, drowsiness is carrying on. So therefore,
so my first question is, statute says on receipt of an application with subsection 1, the court may, where it is appropriate, and it is so requested by a party.
Right.
So if I am the person who is filing an application with 34(1), can I file under 34(4)?
Sir, thank you so much. Which leads me, and which is why I am carrying this with me. Because when I saw this, and I saw a mind which does not think in straight lines. How the question is framed. I am quite cognizant of how the question is framed. Now, do you realize how the question is framed? The question says, whether a party challenging the award can file an application under 34(4) of the Act or the arbitral tribunal to resume proceedings to eliminate grounds for setting aside the award. So what is the scope of the lecture, so as to say, before us? It's not about 34(4) generally. It's about 34(4) in this particular circumstance. And honestly, when I first read it, I said this is a mistake. Then I realized who it's coming from, and I said no mistake. No mistake. This is deliberate. This is deliberate, and this is so think. Now I am asking you this question, and this is the same question which Sir has put. I have got, there is an award. I somehow, and I'll deal with this later on. Where is this? Yeah. So I will deal with this later on. I have an award in my favor. Sorry, I have an award. Let's put it this way. I am challenging that award, which means that some part of the award I am not happy with. And then I only move a 34(4) asking for the grounds for setting aside of the award to be considered by the arbitral tribunal. Now, can you visualize the situation when this can happen? I can visualize the situation where the other side can move, saying that listen, the party challenging under 34(1) has raised an issue with regard to certain grounds so that the award may be set aside. However, my lord, let me tell you this, that these are gaps in reasoning which can easily be seen by the tribunal and therefore remitted back. But this is the other side. The question here is framed the other way around. So we'll deal with this question. When will they do it? There is some case law. There is some case law to support it, or to suggest that it has been done. Whether it's been successful or not is a separate thing. So the first sequitur to all of this is, why would a party do it? Number two, will it be successful? But that's the second part. Now, why would a party do it? Any response? Any ideas?
Because the threshold for 34 will be higher, but whereas if I can challenge one part under 34 to 1.
No, please. Again, consider. There is an award. I am challenging the award. Once I challenge the award, what is my purpose of challenging the award? What's the purpose? To get it set aside. Perfect. Now I move 34.4. What does 34.4 do? It says the grounds for setting aside of the award may go. So if I am moving an application under 34.1, why would I move under 34.4? Yes, please.
Expedite the enforcement.
Expedite enforcement.
So that it gets over, it's not set aside.
No, but you see, there is no compulsion on the court to refer it back. It's only an application. Why would you want to, you would want to move 34 only to, when you are challenging it, only to delay it further to get more mark on your face than you already have, because you are before the same arbitrator. Exactly the point.
Get a sword hanging over the arbitral tribunal to maybe pass the particular issue in the favor of the party actually putting forth the 34 for application.
Just come again. Sorry.
Put a sword over the arbitral tribunal to decide in its favor. That's
No,
the only
you can't change findings. So I'm coming on that. Yes.
See, it could be like I have 10 claims. 6 get allowed, 4 don't. So if I get the matter remitted, maybe the 4 also get allowed. So therefore, then I don't have to challenge it in future.
So sir, the only difference here is, and I'll just come to the case law. The case law says, and I've got, the last 2 slides are my slides of what I deem to be my conclusions from this. So the first conclusion is that if there is no finding, you cannot remit. If there is, and Justice Bhakur in the Delhi Metro Rail has made it very clear that there cannot be a reappreciation of evidence or reopening of the matter to change the findings. Which means that if your counter claim, if there is absolutely correct, why would you move it? Because you have 10 claims. There are 4 which are decided in your favor. There are 6 decided against you. You may find only for the 6 which are decided against you. But what you can't do is change the findings. This is what the courts have said in the 34th court. So if you can't change the findings, why would you file 34th court? That's what I'm saying, that when I read this question and I read it 35 times, perhaps more, to understand whether this was this, but as I said, the author has something in mind, and therefore it probably made me do more work than I would probably have done on the 34th court otherwise. So there have been some case laws, and the first case law, first of all, okay, now I want to digress, because before I come on the case law and the findings, I understand I don't have too much time, but what I want to start off with is, you don't come to 34 court straight away. You first have to see the award. Okay, so again, this is again from practical experience, because I personally find, and I'm telling this to a lot on my left hand side, and this is something that I have been taught by my seniors, including the one sitting here, whose dictum has been that your treating your file is your Bible. This is the word that I heard from him from the first time. I think every junior who has worked with him has heard it. What does that file contain? That file doesn't contain law. That file contains facts. If you don't master the facts, you can never master the law. So the first thing you must do is read the facts, read the award. Once you read the award, you will find that there are certain claims decided in your favor, there are certain claims decided against you. Then you have to do this. You have to analyze the strengths and weaknesses of the award, whether you feel, the first reading always gives you a basic instinct. It's just a thing that comes in, yeah, galat kiya hai, which there's something wrong. Then you come to whether there are any computational, clerical, typographical errors, because then 33 comes in. So before 34, you have 33. That remedy is still available. So don't lose sight of 33. Read the award, analyze the strengths, check whether they have any other claims have been missed out. This is where 33 what 4 comes in. 33 4 comes in. So that if there is any claim which has been missed out, but this has to be with the consent of the parties, please. So this is not something suo. I mean, you have to have the consent of the other party, and why would the other party give consent? That's the other thing. So from a practical standpoint, theory it's okay. You can seek the consent, but why would the other party, unless he feels it's something that could go in his favor, so therefore let me have a traditional award in this. Then, the last part is the one that is more relevant to the 34th award, which is check if all issues have been decided and findings given on each issue. Check the reasons that tie up the evidence to the findings. Somebody asked, I think Kansha asked, what do you mean by the reasons? So this has been defined as the links which associate the material you use to reach to a conclusion to be able to reach a conclusion. So findings are the conclusions, evidence is what has to be considered, and in between is the link, which is the reasons, which we call the third pillar of our principle of natural justice, that you must give reasons, and 31, I think it's 31.3, which basically says that our awards, so let me just check with you, I don't know, I had my share of badams.
Yes, 31.
Reasons, huh?
31.
31, so not bad. Yeah, arbitral tribunal shall state the reasons upon it is based, but there are exceptions. The parties have agreed that no reasons are to be given. It normally never happens. I haven't seen it that parties will agree that no reasons need to be given. And then it's an arbitral award in the agreed terms. So basically reasons have to be given. And the reasons, I think, are at the core of 34. So where I am coming from is that as far as 34.4 is concerned, once you have passed the stage of 33, and 33 also, please remember from a practicing lawyer standpoint, it has a period of limitation. So that period of limitation, I prepared some slides of 33, which I don't think I will go too much detail, under much detail. I think it has been covered by Kansha to a large extent. I just want to say that this has to be done within 30 days. If you file after 30 days, and then you file a 34-1 after waiting for that rejection, then again the court will say, sorry, if your 33 was not filed, I will then count the period of limitation from the date of the original award for 34.4, and therefore if you count that period, then again you may get into a limitation issue. And then the power of interpretation, insofar as interpretation is concerned, again, interpretation against the consent, unless otherwise agreed, interpretation can be done. It cannot be for a review or re-examination of the award. This is only for interpreting the award. But again, make sure that you pass through the stage of 33 before you think of 34 or before you think of 34.1. 34.1 anyway has to be done because there is an award against you. These clerical errors are not going to save you from this thing, but these are thresholds that you need to cross so as to get as much clarity as possible, so that when you move 34.1, you know what you are after, fully and finally. Then again, this is on, again, so this is the additional award part which Akansha dealt with. Again, these are some of the things that the arbitral tribunal needs to consider while making it. And then 34.4. We come to 34.4 straight away. Now, as I said before, and I'm going to just, in view of the time constraints, I'm just going to limit myself to a few issues. The award would have no findings. If the award doesn't have a finding, 34.4 will not apply. If the award is patently illegal. Now, patent illegality is a very grey area. It's an extreme grey area today. And I don't know, it's been introduced, and that's the thing that every one of us uses to be able to get an award set aside, patent illegality. Which typically actually means the 28, the conditions which are set out in sections 28 have not been followed, which is that you've not followed the law, you've not followed the act, the arbitrator has acted as a mediator, more than an arbitrator. All of those, or you've not followed the contract. All of these are patent illegality grounds. Now, if there is patent illegality, so that the award needs to be set aside, again this will not be done. Then, so where it can be referred, and I can't say refer because I'm using the wrong term here for revision of a reference. The section and the judgment say that the court will merely adjourn the matter after noting down the grounds for setting aside, which are curable. So the question is, what is curable? So here I'd like to just read one part of 34.2, which could be one of the answers as to why somebody might move a 34.4 application. If you look at 3, the 2, the party making the application was not given proper notice of the appointment of an arbitrator or of the arbitral proceedings, now more importantly, or was otherwise unable to present his case. That last part I think people miss out. Was unable to present his case. Now, an inability to present your case can arise from the fact, and this has been done in some decided cases, where after the hearing, somebody moves an application or produces an affidavit. After the arbitration hearing is concluded, you moved an affidavit now. The other side has not got a chance to hear it, to get a hearing on that, or to get a cross-examination on that. The arbitral tribunal considers this and passes an award. That could be one of the grounds for a party who is challenging the award to also move 34.4, saying that in this case, you had a fresh piece of affidavit coming in. I was not given an opportunity to plead my case, so therefore reopen it. It's a ground for setting aside, but it's a curable ground. It means hear me again. But again, while this is one part, the second part is, if it results in a change in findings, will it still be referred? And that's a grey area. Honestly, it's a very grey area because according to the Delhi High Court, you cannot remit or you cannot remand or your arbitral tribunal cannot look at this to reappreciate evidence and to deliver new findings. But this matter in which a fresh affidavit has been introduced, which has been considered, but the other side has not been heard, the question mark is, will the arbitral tribunal now only hear you to now make up its firm mind that what I passed was correct? Or will it go into the question that what you are saying in your cross-examination is correct and therefore I could not have passed that award? It's quite a grey area. To my mind, I think if you read the judgments clearly, the judgments say that there is enough play in the joints for the arbitral tribunal to act. In fact, they say the court has no power to, as rightly said, to modify an award. We are waiting for the judgment. I think it was heard Friday, but I don't know whether it's been concluded or not. I don't have the things, Gayatri's case, and likely to have a huge ramification on the 34-4. Because if the court gets the power to modify, so if they get a chance to to allow modification, then to that extent, whether modification along with 34.4, read with 33.4, how these will move. And I hope that, all of this is discussed, and so therefore at least lawyers get a chance of telling their clients as to what to expect. Right now, for a professional, it's very difficult to tell the client कि कुछ भी हो सकता है. तो वो कहते हैं कि अगर आपकी क्या जरूरत हो, हमें भी पता है कि क्या हो सकता है. So hopefully we should get some benefits out of this. Some law, and basically they should do it. So this was one of the cases in a decided in Madras High Court, Madurai bench, where a matter was kept in abeyance to decide on this issue, that there was some fresh evidence which was brought, and there were two parts there. And the second part also, they said that we had leave it to the arbitral tribunal to decide. In fact, the arbitral tribunal can decide not to decide. So the power to the arbitral tribunal was absolute. You can do whatever you want. The principle, I think, where most of the courts have relied upon, which is unambiguous insofar as 34 is concerned, is that you have the material in hand on one part, you have the findings on the other part, but there is the link between, or the reasons are either missing, or they are inadequate, or there are gaps. Now, if there are no reasons, now again that comes to the grey area of patent illegality, or saying that you never agreement has to be a reasoned one. If there are no reasons, whether the award should be set aside or whether the award should be remanded on an application for 34(4). If there are no reasons, if there are inadequate reasons, if there is a gap in reasoning, is one part where courts have said that listen, you can do a 34(4) to fill up those gaps. But what if there is no reasoning? But apparently courts have held, at least in a couple of matters, that even if there is no reasoning, then also 34(4) may be applied to send it back. Now, why would you want to do it? Why would a person want to, again it comes back to the question, I have an award, there is an award, I have not, there is an award. I am unhappy with the award. Now, unless I am unhappy with some part of the award, and therefore want a 34(4) for that part of the award other than the part that I am objecting to, is again a question mark, because then the award that I am not objecting to doesn't form part of 34(1), where 34(1) is only for the part that is against me, not for the parts which are in favor. So you need to mold your 34(1) application, to be able to utilize 34(4), to be able to get some benefit out where you feel that I have not been heard and therefore a fresh finding is possible. Or there was a fraud which happened, or there was a miscommunication. In one case, there was a statement made that a particular product came from godown 1 to godown A, and which is why the arbitral tribunal denied the award. Later on, an RTI was filed and it was discovered no such movement took place. Now this took place after the award. So whether that could be taken into account to be able to change or modify the findings, which again leads us to the same issue. Can you modify the findings? Delhi High Court says you can't reappreciate evidence, you can't do it. But in a case like this, perhaps there will be an exception. Which is why I am saying the law will follow the facts. Facts as they are. If there is evidence on record and there is a finding and there are some reasons, the court will not remit the matter for a refinding for a refinding or a reappreciation of evidence. But in a particular case, if something has been completely ignored, maybe it is possible for the court to remit it for the 34(4), saying you apply your mind on this, come back and then we have to look at it. Again, a grey area, but to my mind, if you do a purposive interpretation of what this act is all about, then this is how it should be interpreted. So again, once the award is remitted back, it's actually the word used here is remitted back. I mean, there is a lot of language on revision. One part of the judgment says that you can only adjourn it and give the reasons and leave it for the tribunal, which means that you applied it for 34(4). The court considers the matter, says there are grounds for setting aside the award, which are curable, and says we are adjourning the matter for appropriate action. And then it is for the parties to then approach the tribunal to say that listen, this is what the High Court has said, please have a relook at it and then consider it. So technically is it a revision or it is a mere adjournment to allow? We are loosely using the term revision, so don't hold me to it. Tomorrow if somebody says that somebody said that it can be remitted by the court. So because there is some case law to say you can't remit, you can only adjourn. So again, this is the Gayatri Balaswamy IIC's Novasoft case, which is now considering on the modification part. It's going to have a huge impact on 34(4), I believe. So now you will come to we have some case laws here. which have actually dealt with 34.4 in some fact situations. And I have some farras prepared for this. So I am going to refer to some of those farras to be able to. So the fact here, and this is one of the cases where the person who challenged the award or moved the 34 also moved the 34. And the facts were that after the conclusion of the arbitration proceedings, an affidavit was filed, the award was was passed considering that affidavit, and therefore there is a challenge, and therefore also 34 application saying it. And the Justice B. Balasubramanian actually said that court has only power to adjourn, it has no power to remit, but there are grounds here which are there for setting aside, and therefore I am going to remit. I am going to adjourn these proceedings to enable the arbitral tribunal to have a look at it. This is what they had. So, for the conditions, the three conditions he said were that an application under 34(1) of the Act to set aside the award has to have been received, court considers it appropriate, and if it is so requested by a party. So, and this was a case in which the person actually applying for setting aside actually moved 34. So, one of the matters where unable to present your case, which is your 34(2) part, was there. Then, listen, I mean, any questions on this? Because I think, because otherwise I will be going through some case laws which are going to reiterate what I have already said earlier. There is no findings, sorry, no 34, Supreme Court referring the matter to Supreme, and I can come straight to the scene that there is not too much of time there.
No, you have enough time.
We have time? Okay. So this was MMTC Victimas. Yes, please.
The 34 to says that beyond the scope of application.
34
to A4.
34 to A4.
Which talks about award being beyond the scope of arbitration. Matter is not submitted to the arbitration, but set aside.
Yes.
Does that have a correlation with 34.4 to say that go back and determine your jurisdiction?
Again, very difficult.
That's.
Is it question here is that, listen, the case law that has developed today is that the courts are very reluctant to interfere in a 34 finding.
But if they are setting it aside partially.
You see, most of the disputes, let me tell you that, and I'm again talking from a very practical perspective. Now, some court might consider that, listen, there are some grounds for setting it aside, but so let's put it this way. And I'm again using the same analogy. There is evidence, there is a finding, there is a gap. If there is no gap, then can the matter for even adjudication on the provisions of variability?
Provided that is the decision provided that is the decision the
Matters submitted are separated from those not submitted. Are you talking about the provision?
Yes, yes.
Yeah, only that part which concerns decisions not submitted may be set aside. Right? So again, if the arbitral tribunal has seen the evidence on record and arrived at a finding, and there are enough reasons in between, there is no ground for setting aside of the award. I am saying that no ground for remitting the matter back to 34(4) because finding is there, material is there, reasoning is there. Basically, where I am coming from is that under 34(4), this is the link you have to establish. Is there a gap in the reasoning? Is there inadequate reasoning? Or is there no reasoning? But there is evidence and there is finding.
That is the narrower limited scope.
That's the narrower limited scope of 34(4) in some cases. Now in the case which I talked about, the last case, the Vignimas case, there it was an additional document filed on which there was no determination. So while there was a finding, the question was that I was not heard. I should have been heard. So while there was a finding and there was material which is that particular piece of evidence and the material, yet it was not there, the principles of natural justice came. So some other part of 34 will apply, perhaps not this part. But for these parts to apply, you have to look at whether the decision under 16, for example, that they made, was it consistent or was it consistent with the material on record, on the facts of the record? But it was, and there is reasoning enough. The court will either say good or it will say bad. It may not remit the matter back because you can't improve the finding. As I said, you can't change the finding. You can only add reasons to it. This is what Justice Maadhyam, the Delhi Metro which just come, has said. There the issue was, again, the person in whose favor the award was also filed 34-1. That's the second case. Beyond that, I am not able to look at anything else. But 34-1, just let me complete this. Facts in that case were, I was supposed to get some money for working on a hard strata of rock, where my contract said that you are supposed to work on a softer strata of rock. So they said that, listen, since I was to work on a hard strata, I was supposed to get this much compensation. The judge, the arbitral tribunal awarded compensation, but I was not happy with the compensation awarded. So I moved an application for saying that this claim is wrongly decided. And I also moved 34-4 saying that now if you look at this evidence, it will show that I am entitled to a higher sum. So while the award is in my favor, I am saying that I should have been granted a higher sum than what is being given. So that's another case where you move 34-1, I also move 34-4 saying that please look at the evidence. So, but the Honorable High Court has said that I will not allow the findings to be changed. I will not allow reappreciation of evidence. Whatever is there, they have appreciated it, it can't be done. So we are looking at that scenario. So I am saying you will have to, again, there is no law on this. This is what I started off by saying, that you will have to look at the facts and you will have to look at your client's interest. Is it in your client's interest to get a worse award in this favor? I mean, you already have an award which you have challenged under 34. I would say your best bet would be to get it set aside, not give it to 34-4 for further clarification so that he further damages you. I mean, here the arbitral tribunal which is against you, you moved against him, and obviously the 34-1 will be with him. He'll know non-application of mine will make several allegations, won't go down with the arbitral tribunal. Then you are asking him to give further reasons. You say, I will give you reasons.
Probably, by giving further reasons, the arbitrator, it could be clarified that there is an illegality or something wrong, patently wrong, to come to that conclusion of the finding.
So that part, they say in 34-4 you can't do. You cannot change your finding.
So you don't change the finding, but by reasoning you can demonstrate that it was patently illegal to come to that finding.
Correct, but the problem is that if the evidence has been gone into, then if you are changing the finding, that is now then within the not within the scope of 34. Then you go for 34-1 and have it set aside, saying that this is patently illegal. So patent illegality, courts have held very clearly that if this is a case covered under patent illegality, then 34-4 will not apply. So the question of course is, what is that grey area between a pure patent illegality which cannot be rectified and a patent legality which can be curable? So that is something the facts will determine, whatever the facts are. I can only show you two case laws where people who have filed 34-1 have actually applied for a 34-4. So one was in a case where he got lesser compensation than what we would have wanted. Result, not allowed. Another one was additional affidavit filed, result, allowed. But otherwise, as Pankaj rightly puts it, you go before the trained tribunal, the chances of your getting, and after 34-1, when you made all kind of, statements that this is not being considered, that is not being considered, for the arbitral tribunal to then take a software, you will have to be next to God to be able to do that. Please, sir.
If you just go to the second part of it, 34-4, it says, the second part of the column, adjourn the proceedings for a period of time determined by it. With the hearing period of the court will determine.
3 months, 6 months, normally that's what
Whatever it is.
Yes.
In order to give arbitral tribunal an opportunity to to resume arbitration by part, or take such other action as in the opinion of the arbitral tribunal to eliminate the ground for setting aside the arbitral award. So if I was to read the last words, resumption would mean as if there was no award.
No, so here,
1 minute. Would it not mean that?
No, not in the context of
For the moment, delete the last part.
I am deleting the last part. I am
So I
deleting
am
the
saying
last
that
part.
resume arbitral proceedings. It will take me back to as if there was no award. Then it says arbitral tribunal can take any action as in its opinion. So I may apply for additional evidence, take that into consideration. But if the additional evidence is allowed, resumption of arbitration proceedings are done. I will have to be.
Absolutely.
And my second part of that question is that when that supplementary award comes, supplementary award, and Raja rightly said, would have to be into the award.
It has been merged.
Supposing the finding or the has come against me, whatever is the reasons given right against me, will I not get a fair bit of immediate?
It should be. It should be. So let me just answer it.
The judgments of that are not talking about it.
No, the judgments don't talk about it. The judgments of
That's why
24 are very...
Judgment is a basic one, just saying.
No. That judgment is on modification.
That's what I'm saying.
No, that judgment is on modification. But let me just tell you just one paragraph from this one judgment called, again the same one. I think it's MMTC Dictavas. So there what they have said is, court adjourned the matter and said the arbitral tribunal can do whatever. They gave complete freedom to the arbitral tribunal. They said, I can't do it, the court cannot interfere with that. It can either set aside or it can reform. It cannot go into anything. So in McNamara's, they gave complete freedom to the arbitral tribunal to do whatever it wants. But I think the start point is 34.4, the grounds for setting aside, which are curable in nature, must be mentioned. So now what will practically happen? Practically what will happen? You have moved to 34.4. The court has to make up its mind as to whether 34.4 is maintainable, for which it will have to go into the question whether there are grounds for setting aside. Once it finds there are grounds for setting aside, then it will have to determine whether any of these grounds for setting aside are curable. It will have to list those grounds which are curable, saying these are the grounds curable, and therefore we are adjourning the matter for a period of 6 months to enable the arbitral tribunal to have a look at it. Then the party will go back to the arbitral tribunal, say this is the order that has been passed. Now, sir, please decide. At this point of time, what McNamara says is the arbitral tribunal has full carte blanche. They can do whatever they want. Full carte blanche. They say court can, it permits the arbitral tribunal to do whatever it wants. It says complete play in the joints. That's what it says. But at the same time, my sense would be, again from a practical point of view, is that when the arbitral tribunal resumes this, it might be constricted in its view of what the High Court has said are the grounds for setting aside and that they are curable. My sense is the arbitral tribunal will not go into further findings or reverse the findings completely. It can, because other reasonings say you can only fill in the gaps. You can fill in the gaps. Gaps means the finding remains, material evidence remains, the gaps have to be filled. It means additional gaps need to be given. Unless we follow again McNamara's case, where a fresh piece of evidence was reduced after the arbitration hearing, on that perhaps there is a possibility of a fresh finding. In which case the court has said you have full carte, do whatever you want. So arbitral tribunal, in that case, if he passes a fresh award or changes the finding, I think, let me assure you that I personally feel that in that case the other side will go for 34 and that will be set aside. Because you can't have a arbitrator saying one thing at one point of time, second thing at the second point of time, material was the same. You can't change findings just like that unless of course there's fresh evidence that is needed and which is permitted. So even on fresh evidence, so there is a reference by in this judgment perhaps or in some other judgment which talks about Russell and talks about the list of things which have to be considered before you, if you file an evidence after the arbitration proceedings have either concluded, and for that they say that you had to have no knowledge of it. By exercise of due diligence you could not have come to it. It had a material bearing on the award. So some conditions need to be fulfilled before you can reduce any further evidence. But I believe that if you do reduce this and then use 34, maybe there is a possibility that one-off exception wherein fresh finding can be arrived at. Perhaps there is this window, the slight window there for you to do it. That's what I'm saying. So 34.4, okay, so let me give you a live example, something that transpired about 3 months back. We were in Rajasthan High Court and in a section 37. And the issue was, there was a GST claim that we had got in our favor, and that was being challenged by the government of Rajasthan. And the other side's argument was that there is a calculation given, there is a finding given, there is no reasoning that is given. There is no reasoning that is given. So therefore the senior in Rajasthan, actually Ranga says we have taken a half-an-hour break to consider whether we should move a 34.4 here. To say that the arbitral tribunal has not given the reason, 34.4 is meant for to give the reason, the finding is there, material is there, to give the reason. We conferred, we decided that we will live with it. Let's not take it back, because taking it back means God knows how much time, and again getting it back to Rajasthan court and to be able to get it heard. I said it will be an impossibility, we'll live with it. So it's a practical call you take at that point of time as to whether you would want to move it. You have an award in your favor, would you want to still move it and then admit that listen, there are gaps in you. So for 34.4 to be moved by a person in whose favor the award is, you are admitting that there is some gap. Unless of course you feel that the court is now coming to the conclusion that listen, there are gaps, in which case better get your act ready and move a 34.4. Because instead of getting a setting aside, at least try and get a reasoning to it. Again, practically, it's to be considered at that point of time, you have to take a strategic call what to do. Very difficult in terms of theory to suggest in every situation the same answer will prevail. Yeah, you can. So there is, again, Supreme Court in one case has considered, he says that you didn't move it before the single bench, you moved the 34.4 before the division bench. So Supreme Court says that assuming that this is a continuation of the proceeding and 34.4 is there, it's just saying 34 is not maintainable. So luckily they didn't hold it maintainable, but they did mention that there is a 34.4 not moved at the first stage, award is set aside, then it is moved in the division bench stage, but they didn't go against that saying that it's wrong. But they didn't say it is right. They simply assuming that this is correct. Now this is part of Supreme Court orbiter, perhaps we live with it. Perhaps you can take that to mean you move it at any point of time. And take your chance under the Supreme Court, you have one body to help protect everything. This is not good. Very good. It has given
May I
up on
ask
you.
one question?
Yes, you can ask a question, but can I ask a question on this computer? So since this is not moving my findings, I wanted to just bring my findings slide. So anyway, we'll take a chance if it comes. So I just wanted to show the findings. There are two slides on what I believe after reading through these case laws. What I believe are the touchstones of 34 and when it will or will not apply. I put out 2 slides. I can't somehow get this computer to respond to me.
So there is this concept that award, as soon as it is rendered by an arbitrator, the arbitrator will become Pankaj Sufficient.
Thank you.
So this 34.4 is an exception or is in line with this concept of Pankaj Sufficient, since it has limited scope?
So, Madhav, can you hear me? Perhaps I can sit down. Yeah, so the concept of functus officio is basically a concept that comes from what a arbitral tribunal's powers are under the statute. So normally you would say that once the award is rendered, the arbitral tribunal becomes functus officio. But for 33 it has powers again for the next 30 days. So it doesn't become functus officio. After 30 is moved, 33 is moved, he'll have to give a decision. So till such time it doesn't become functus officio. Then, so under 34, when the power is given to adjourn, and then the arbitral tribunal is to consider it, therefore to that extent functus officio again goes. So ultimately what is functus officio is a reading of the act and the powers. Otherwise even under 33 it will be functus officio. So the award has been given, you are asking now for clerical errors to be changed. Yeah, please.
You can refer to 32, also section 32, subsection B, and very clearly mentions that how the mandate of
No, I had no idea what the section is.
the mandate of the ancient government. This is subject to 34.
Right, but 32(1) says it shall be terminated by the final award.
Exactly, but this is subject to subsection.
Right, but if you see 32(2), it doesn't talk about these 33(3) or subject to 22.
Two exceptions are in there.
Otherwise, we take it that any court, if we feel that there is a power which is vested in the arbitral tribunal even after passing of the award, no court is going to disallow that. Because that power is vested by virtue of statute. How can it be functus officio and still exercise that? It's just not possible. So we have to give that purpose meaning to each one of them. Then you have, so I have listed out a number of cases. You can, if anybody wants to take a note, Skinari Malik, China Technologies, Maadhyam, you have IP clearing, lack of finding of the key. So IP is another interesting one. In this case, I'm sorry, there is a question to be asked. Yes, please.
Good evening, sir. Maybe I'm a student, I'm a law student. Maybe I felt a little bit left behind at a particular point. I just wanted to ask in regard to section 32, which was raised right now, and specifically section 34, part 4. Is section 34 for part 4 right available to the parties, or if in case it is not being provided, then an appeal can be filed under section 37? By how to explain it?
37, no, 37, you have, okay, so now I have to read 37 as to what are the appeals which are permitted. Against that order, if it's there, that's 37, you can't. Okay, so when is 37?
So my question is related to section 34, subsection 4.
Yes.
Basically, if in case, my first question was that, is it a right available to the parties in section 34, subsection 4, where the court can provide the arbitration to consider the matter again? And
Yeah, okay. So let me just, so does any party have a right to file 34? Answer is yes. Whether you will be successful depends on the court. And the court will have to consider whether it is appropriate for 34(4) to be invoked. देखो जी, हिंदुस्तान में फाइलिंग से तो आपको कोई रोक नहीं सकता. फाइलिंग के बाद काउंसिल को डांट कितनी पड़ेगी वो बात अलग है, बिकॉज आपके अगर ग्राउंड भी अच्छे हैं. तो so counsel जो पेश हो रहा है ना, he should be very clear कि what he is arguing is at least plausible. I mean इतना idiotic नहीं होना चाहिए कि उसको डांट पड़ जाएगी भैया ये 34 तू या तो विड्रॉ कर ले या फिर मैं करूँगा, तो कंसिडर दैट. अदरवाइज फाइलिंग से कौन रोक सकता है? I mean, you can stop it from filing. Nobody can stop you from filing, but just be mindful of what you are filing. And the court will consider it and then pass an order. So it's not a case. So again, this has also been decided in a case where they say that mere filing of a 34(4) doesn't mean that it has to be, the court must adjourn. So the court will, I'll come back to it. So the court will consider the application, see if there are grounds for setting aside, see whether those grounds are capable of being cured. So if they are not capable of being cured, if they are so badly run down by patent illegality, then it will be set aside, not remanded to 34. So coming now to IP clearing, here the first issue that was to be determined by the arbitral tribunal was whether the contract was abruptly terminated, suddenly abruptly terminated. So, and subsequently there were issues with regard to various claims. And now we come back to what Mr. Singh had said, Mr. J.V. Singh had asked earlier, and I'll come back. I'll come back to this. There could be some portions of the claim which need not be monetary in nature. You could ask for a small declaration. You could ask for a statement saying that you are in breach of a contract, and then claim your remaining claims which are monetary in nature. In this case, the arbitral tribunal didn't decide the first issue, which is whether this was wrongly, illegally, and abruptly terminated, but proceeded to decide on the claims. So there was no finding. There was no finding on the first issue. And since there was no finding on the first issue, how would the rest of the claims survive? So they said that because there is no finding, we are not going to refer this matter under 34. Because there needs to be a finding on a contentious issue before you can do it.
Bobby, the case I was thinking about was where he says the employer says this, the contractor says this, the termination is illegal. Beyond that, there was no reason.
I pay is ditto example. I pay is example. I pay is example where he never goes into the question of termination. He doesn't say termination is abrupt or illegal, but he says that because there was a termination, I am awarding you this much. So there is no finding on a contentious issue. So sometimes there are issues which are I would say non-monetary in nature. Maybe some of those issues can be referred. But provided you provide that link between the material on record and the evidence, the decision. Then Metro Rail is the one where I was talking of the enhancement of the award was claimed, saying that you didn't look into the evidence, and they said sorry, I will not really appreciate evidence. P. Nagaraju is one where, now look at 81. From the conclusion reached above in both sets of cases, it is evident that the awards passed by the learned tribunal are in both sets of cases, as is evident that the awards passed by the learned arbitrator are to be set aside. They are to be set aside and again, and the matters are to be remanded in terms of 34(4) of the 1996 Act, so as to enable the learned arbitrator to find reasons to arrive at that conclusion. So this is the issue. I mean, this is the issue, but this is the Supreme Court. You can't find fault with the Supreme Court. In larger interest of justice, they can do anything. 142 is there. Perhaps the High Court could not have done it. Perhaps in a certain case you will need to get a decision against you, then move the Supreme Court and then further. So something like that. Again, this is a practical aspect. From practically speaking, you have to consider this. Then there are subsequent references. I've got reference to 5 judge. Okay, so these are the key points that I had listed out according to my readings, and which is why I said they are neither exhaustive and they are not conclusive. They are not conclusive because I don't happen to be the Chief Justice of India. So they can't be of the Supreme Court. Of the Supreme Court of India. So they are neither exhaustive, they are not conclusive. These are my own takeaways from whatever I have read so far. I could be completely wrong. I could be proven completely wrong. And so therefore the first one is 34(4) is intended to make, I just read it out so that if there is any question on this, perhaps I can take that. Section 34(4) intended to make an award enforceable. What's the reason for 34(4)? The reason for 34(4) was to make the award enforceable after giving arbitral tribunal an opportunity. This is very important. It is to sustain the award, not to not sustain the award. That's the principle. But as I said, there could be additional affidavit, additional evidence, perhaps a new finding, but perhaps this will not detract from the findings earlier made. Maybe that could be one of them. And this is again I have taken this now all from either Supreme Court or High Court cases. None of this is my saying. There has to be an application under 34 court and a written request by a party. Court is only a written request also comes from one of the judgments. Otherwise, it just says an application of a party, doesn't say written. Court is only to adjourn and not limit the matter. Award must not have been set aside by the court. Either asterisk, Supreme Court is permitted to do so. Challenge to the award has been set up under section 34 about deficiencies in the award which may be curable by allowing AT to take measures which can eliminate the grounds for setting aside the award. So your challenge should be curable. It should not be incurable, which is why the patent illegality on the face of it, which is so, what is the term used by Justice Nariman? Which is so, what is the word used? So on the face of it, it is so rigid that it, on the face of the record is so, there is a word that we use. Anyway. Associate with the so he said on the face of it, there is a specific word for it. But anyway, it basically it says something which is no patent legality to have, but anyway, it's part of social business. I will take it out. Challenges to the order come to my mind. Allowing to take measures, the court has to exercise discretion, and therefore application of mind in adjourning a matter upon the application under 34(4). The court must lay out the grounds for setting aside which are curable and in which the matter is being adjourned. This will enable the AT to focus on the issue concerned. That is important. And my dear friend there who is looking into his thing, who asked me the question, this is the answer to your question. He is still looking at the phone. If award is patently illegal and not capable of rectification, 34(4) cannot be exercised. Okay. So patently, again, we are looking at a grey area. Totally patently illegal and patently illegal to certain extent where it is curable and therefore you can do it. Cannot be exercised, the power to be exercised to cure defects that are curable. This is a matter of fact which has to be seen for each case. Again, facts, very important. Facts. If there is evidence and there is a finding, but there are either no reasons or inadequate reasons or gaps in reasoning, 34(4) may be exercised. This is the takeaway from the discussion, that in this case certainly 34(4) will apply. So this is one thing which is very clear, that 34(4) will apply if there is evidence, the finding, but gaps are there. The rest is a little bit of a grey area. Remission of matter to AT under 34(4) cannot be permitted in absence of findings in the award on the contentious issues. In other words, if there is no finding, then 34(4) will not be exercised. This is the ideal judgment. So then third scope, it does not extend to remanding the matters to AT for reviewing the finding in the award returned after appreciation of evidence or a decision afresh. This is Delhi Metro, Delhi High Court. There is no re-adjudication of a dispute under 34(4). However, if fresh evidence has been introduced after hearing before the AT was concluded, on which the other party has been heard, the AT may hear the same and give a finding on the award. This is partly me and partly Viknivas. So the first part that it is going to be referred to AT is Viknivas. The other part that he will give a decision is my addition. Then there is enough play in the joints for the AT to deal with the matter once 34(4) is exercised, including no compulsion to deal with anything. It can say, sorry, it will not deal with anything. And then the Honorable SC in certain cases set aside the award and yet remitted the matter to AT. This could be considered an exercise under 142 of the Indian Constitution. So these were my takeaways from a reading of 34(4). I think we have the Honorable Chief Justice. I'm sorry, sir, Chief Guest.
That also from a Chindu.
My original Chief Justice, and I think I'll take this opportunity to pause in my lecture. Probably give the mic over to Sarika.
request my colleague, Mrs. Jaspreet Kaur, to felicitate Mr. Anusha and give a token of appreciation to her. Can I request Mr. J.P. Singh to come and present a token of appreciation to Mr. Bobby Chandier? Thank you so much, everyone. It was really an interactive session. And we now conclude the training sessions, and I'll hand over to Mr. Chandu for the final.
Thank you, the great Secretary General. It has been a day where our experts were able to take us through how an award can be set aside, the distinction between 34.2A and 34.2B. I was wondering and I asked this question. I'm glad my Lord is here. Welcome, my Lord. That if the second part of 34 says, to the court files, there's no 34. But in the execution, the judgment debtor is able to show that court, please find this award is bad in law. Will the executing court not say, I will not execute it? It may not be able to set aside the award, because not in 34. But the word used in the statute is where the court finds. The obligation is given to the court. And the judgment debtor points out that the award is bad. So at least the execution must be distinct. Now these questions are being raised, are coming up. I do not know what will be the end result of it. As our commercial disputes are increasing, as we are getting more and more advanced in international dispute resolution, these questions are ought to come. I thought something would have been thrown light by answer to us as to what are the new amendments the government thinks or the legislature thinks that we should have. But I only feel that time has come that we should adopt to make a committee of a practicing lawyer, and an honorable judge, who would give us the decision with respect to what kinds of things, what difficulties, practical or otherwise, are coming in this statute. So the legislature can be assisted in bringing the correct law with the need of the hour. From 34, we went to a question with an international award. And if the award, which is an international award, was set aside on a section 34, that means part 1 in entirety has been applied. If part 1 in entirety has been applied and setting aside that award, then the resolution or the fresh arbitration has to begin in New Delhi. Because by operation of that judgment, you've changed everything. The question that arose was that how do you do that? I can understand probably by a judgment you can't change the law, but at least between the two parties, the judgment is binding. Otherwise, unless the other party would have challenged it and gone in appeal and said sorry, it would not have passed the judgment. But having accepted that judgment, to me it will remain an international dispute, but the seat of arbitration will change because you applied Part 1. You remember before Barco came, Part 1 used to be applied left, right and center. It took us 12 years to decide in Barco, and that too prospectively to say agreements drawn after the constitutional bench judgment that will not apply. That means you will apply to agreements prior to that. So the Supreme Court by implication accepts Part 1 would apply to international dispute. Then why would that seat not be here? So if by a judgment it is between the parties, I don't think the other side will be able to go back to a divisional seat. The operation of the judgment would certainly come into play. But we'll wait, the matter is pending, and let's see what the decision ultimately comes. The last session, we had 34-4. A lot of judgments have been shown by both Akansha and my dear younger brother, though he doesn't accept that part, but I have to tell him. Mr. H.H. Janjo. Judgments are not dealing with this expression, unfortunately. It says, remit the matter to the arbitral tribunal to resume arbitration. Which would mean there is no award. And then it says, or take such other action, which would also mean fresh evidence. So necessary, why would it be a supplementary award? Why should the tribunal not pass a fresh award after which? If you see, my Lord set aside the judgment, but however remits the matter back to the trial court. The trial court passes a fresh judgment. Though in the garb of saying that the arbitration, so that we are not showing international people that our arbitration is weak, we have brought that picture to say, I am adjourning the case. The moment you say it will go back and arbitration proceeding will resume, you're actually saying what? That you set aside everything. Therefore, the arbitral tribunal must apply its mind. It can take certain action as it wants. Meaning parties can lead evidence. I can amend my claim. I can amend my written statement of defense, and fresh proceeding will start. And the question that none has addressed. The law here, it says, adjourn the proceeding for the time court will determine. So supposing the court says 6 months, arbitral tribunal is still pending, again you will come for extension. Because 29A also says, I can apply to the court for extension. So these are areas which I think before the legislature brings another amendment to the amendment to 1933. It must have these people on board, have a discussion, and then bring that situation which will be able to, of course, for all of us it may be difficult because we will lose some briefs, but it doesn't matter. At least there will be clarity, we will be able to do business better. On one side we say everything is being done to do ease business. Law we are complicating. And if somehow you come to court, we try and see each honorable judge of our court in Delhi has 120 matters. There are recommendations made, not a number of pointed, those are not issues. Here are not anything there. But what I am requesting is that you all need to assist the court now, wherever the opportunity comes, as to what is the actual ambit and scope of Section 34. Why was it done? In 33(4) they said additional award. Here they said nothing. Why did they not use the word additional award here? So we have introduced that word supplementary. Therefore, to me it looks, the moment you decide that yes, there is a case of remanding it back, you must remand it and the arbitral tribunal must pass a fresh award. That's the view I have on personal ground, but we'll see how the Honorable Court deals with it. We are very, very grateful to my Lord to have agreed to be with us. If I start reading his profile, I take the entire day there. It will not be possible for me to finish it. But I met my Lord when Lordship was still practicing in India. I have not seen a single change when my Lord was a lawyer and my Lord is a judge. No change. And I think that's the first quality, because I remember Chief Justice Gordon on retirement in UK was asked how to select judges. He says, I only look at one thing. It should be a gentleman. Doesn't mean no gentlewoman. If he knows law, it's a good. So, in my Lord, I find totally fitting that remark, that is thorough gentleman. And you can't influence him by anything except law and statutory law specifically. And I make that point with you because Lordship first looks at his statute, asks you to master your facts, tell him that's his Lordship will do, how to interpret. These are lessons that we must learn. These are things that we must know. That's how the scheme of the Arbitration Act moves. From 40, we got a change in 96. 96 is also amended from 2015. And many of us would know there was section 26 in the Amendment Act, which said it will not apply to pending cases. But 26 never formed part of the statute. It was only in the Amendment Act. And still we are interpreting 26. Then 87 came, 87 is struck down. But also appreciate and assist the courts in coming to a right conclusion. Much will depend on how we present ourselves. His illustrious legal journey, as I said, unparalleled dedication, prestigious distinctions of Advocate on Record, Supreme Court of India in 2001. These are awards. Practice in almost every field, every tribunal, the tower point that he had, Additional Advocate General State of Chhattisgarh, Standing Counsel for States of Madhya Pradesh, Uttar Pradesh and Jharkhand. His illustrious portfolio representation includes eminent entities like Government of India, Police Authority of India, and so on and so forth. But I want to say something more than this, to my mind. When his Lordship came to Delhi as an honorable judge at the Roni Bench, I don't think any one of us thought that he's coming from Allahabad. It was always thinking that his homecoming was Lordship. He was wrongly appointed in Allahabad. He should have been appointed in Delhi. And we are glad that the Lordship is with us. We depend on you on many things. And the fact that you have, at our request, come here to be amongst us itself gives us a reassurance that nothing is lost. It is still at the top of our legal profession. The dispute resolution is an important facet, and the alternative, especially dispute, whether it's mediation or it's arbitration, we need to understand that so that we are able to give to the person who is seeking justice in terms of our constitution what it requires to be done. May I request my lords, please join us. While we welcome your lordships not amongst us, we feel that we need from you a path or a guideline that we as lawyers, especially our youngsters, should follow, which will take them to a path which will really be able to go into the draw new lines in law. They will assist the court with new aspects. They'll be able to assist the court in drawing new paths and ultimately what we call social justice. Lord, one of us, one of our founding members was Sadhana Ramachandran. Lord, she is aware we lost her last August. We renamed the present series as Sadhana Ramachandran ADR learning series in arbitration. What will go to other aspects in alternative dispute also as time goes by. I think we have not even finished part 1. We still have to go to part 2 and see how we bring it. I am grateful to all my professors. I am not taking your names. Everybody knows you. That you have given us unparalleled support, come all the way to be with us for the day, spend your time, given us your expertise, and helped us iron out many creases that we thought were there in law. On behalf of each one of us and my personal behalf, let me thank you, all my professor friends here. Lawyers, friends of mine, my colleagues, except Mr. Chandra. They are very busy people. It's difficult for them to take time out. Yet at our request, they all came. They were given us the practical view of what they see, what difficulties they face in honorable courts. They also showed us how they would like to interpret the provisions of the Act and how we should enrich ourselves with their experiences. On the core of my heart and on behalf of every one of us, participants as well as members of the governing body of Maadhyam, let me thank all 3 of them. One sitting right in front of me, one has I think gone home. No, here in arbitration. And of course, Mr. Chandra over there. Thank you so much, Ashish, Mr. Gaurav, and Mr. Chandra. Grateful to you. Lord, the family of Mr. Madam Sadhana Ramachandran, in collaboration with Maadhyam, has introduced an award, Lord, which we are announcing today, which is called Sadhana Ramachandran Young Promising Mediator Award. There are 3 people in it. One is the winner, one is the first runner-up, and then the second runner-up. And this is the first award that will be conferred on them this evening. And let me first of all announce those awards. Number 1, the winner is Vishakha Gupta. I know you are sitting right next to the door that you want to run away, you can't. The first runner-up is Sakshi Vijay. She's online. She's in Australia. And she couldn't get a ticket to pre-pone. She didn't know this was coming to. And the second runner-up is Mr. Shivash Soni. Congratulations to all 3 of you. I'm very happy that Sadhana Ramachandra's family has joined us for this occasion. And may I, before we go to the awards, request Mr. Atul Batra to present a plant to his lordship. May I request Jasbir Kaurji to please come in. This is only books, lordship is not getting it. please give the gifts. We have also Lord, we have had 4 episodes prior to this, and we had also announced that our participants who are youngsters and students also, that said all our final year students were knocking at bars and all.
Mr. Chanju was sitting there, sir. And a student of law.
Lord, we have in all those 4 episodes winners of the awards. May I request Rinku, please come and announce them. We want to know from there. Please come. What? Actually, it doesn't matter. You do it.
Good evening, everybody. In fact, it's indeed a matter of great pride for Maadhyam to honor the recipients of the award of episode 1 and 2, wherein the participants were full of energy and zeal in putting up their best foot forward. I personally believe that all of the winners, but the slight difference in making marking or the marking, there were 2 rank holders of episode 1. That is first for drafting of application of under section 9 of the Arbitration and Conciliation Act 1996. This rank 2 award goes to Shantanu George. And rank 1 goes to Vidushi Keshar. Sorry, they are missing her here. She is not there anyway. And for drafting of application under section 34 of the Act, the award for rank of 2 goes to Amit Sharma. And rank 1 goes to Mr. Prikam Singh. And for episode 2, there was multiple choice questions around with regard to the interim relief granted to arbitration during proceedings by the arbitral tribunal vis-à-vis Article 227 of Constitution of India with regard to amendments of 2015 and 2019 of the Arbitration Act, wherein the award of the rank 2 goes to Purva Kohli. And the rank 1 goes to Nupur Agarwal. I congratulate every winner. Once again, congratulations from Maadhyam also.
Good evening, everyone. As we approach the conclusion of today's ADR learning series, I want to take this opportunity to recognize the exceptional effort and brilliance displayed by all participants. The discussions and insights shared have truly elevated our understanding of arbitration and dispute resolution process. Now it's my honor to announce the winners of episode 3 and episode 4. For episode 3, focusing on drafting of arbitration agreements, the rank 2 holder is Pritha Khanna. Congratulations. And the rank 1 holder is Manpreet Singh. For episode 4, which which delved into the jurisdiction of arbitral courts, the doctrine of severability, arbitrability of disputes, and Order 2, Rule 2 of CPC in arbitration. The results were tied in both the ranks. Rank 2 was tied between Satyarth Pahar, Shaheen Bareja, Neetu Tiwari, Tavleen Kaur, and Ananya 2. Rank 1 was also tied between Khushi Swami, Shivam Bhir, and Palak Goyal. Let's give a big round of applause to all the winners for their remarkable achievements. Your insights and hard work have made this session truly memorable. A special thank you to every participant for contributing to the success of all the series, starting from episode 1 to episode 5. Let's continue to learn, grow, and inspire each other in the field of ADR. Wishing you all the very best in all your future endeavors.
Thank you, just BG and Rinku. Only with one correction, that we are not still at the end, which has begun. It's time for us to request you, all these episode winners. We have put your certificates, etc., everything outside on the reception. While you go out and have tea, you may collect them at that time. May I request the first award of Sadhana Ramachandran. Vishaka Gupta. Take out 25,000 along with you folks. Pulkit, would you please come? He is not there. And sometimes his wife gives honors to the husband, so he gets the honor. I have the permission both from Pulkit and Sakshi to announce that the awarded amount is given back to Maadhyam for its activities, especially the trust, which is looking at, as we are having a free medical camp tomorrow in the villages, so to be utilized by Maadhyam for that purpose. Thank you so much. Let's have the second winner, runners up. Shawansu, I've announced already come. The check of 10,000 rupees not granted. I hope we will continue. I'm sure we'll continue with this award. I have also the pleasure to announce that Maadhyam on its own has decided to have an award in the name of Sadhana, Memorial Award, from 2025 onwards. And that's the ADR award, so it may carry go to both, either one either arbitration or mediation, which award will present at our annual conference that we have every year. We have not had the opportunity to go to our governing body to see what are the details of it, but I'm only announcing that and will soon give you the report of it. Requesting you all to remain as part of Maadhyam, continue your endeavor in the alternative dispute resolution so that you could be the awardee in the coming year, this very year, 2025. Let me have the pleasure to request my Lord, the Honorable Justice Singh, to please come and give us few words of his wisdom, thought, and some guidelines for us to follow it. My Lord.
Good evening for everyone. Senior advocate, distinguished participants, esteemed colleagues, lawyers, and students. I am very thankful and grateful to Mr. Chatrio for his kind words stated for me. It is both an honor and privilege to be present here today and be part of this esteemed alternative dispute resolution learning series. This gathering represents a conference of some of the practiced minds in the field of arbitration, seasoned lawyers, renowned academicians, passionate practitioners, and young students. Each bring unique perspective to the involving this course of the dispute resolution. Before going any further, I would first like to thank the organizing team of this event and people at Maadhyam for inviting me to this gathering, and it is always a joy and pleasure to be part of the discourse of the sharing knowledge and experience. I have learned from my last over 30 years of experience, both at the bar and bench, that the legal process is an accessible journey of learning, and I hope that we all have achieved the goal here today. As a practitioner of lawyer for a period of over 23 years and now serving as a judge of Delhi High Court, I have witnessed firsthand the dynamic and transformative role that arbitration and alternative dispute resolution mechanism have played in modern jurisprudence. The subject matter of today's discussions underscores the importance of these mechanisms as concentrates of efficient and effective justice delivery system. Maadhyam in the present lecture series has raised three complex yet crucial aspects of the arbitration law. Firstly, the demystification of validity of section 34(2) of the Arbitration Act, the nuisance of complications of section 34(2)A and section 34(2)B, which raises critical questions about the boundaries of judicial review, preservation of arbitral autonomy, and the interplay between the substantial and procedural law involved therein. Secondly, the detailed examination of section 34(4), a provision which an embodiment of judicial restraint and its interference, thereby offering the courts a rare but powerful opportunity to guide through the arbitration process without undermining the core principle of arbitration. Lastly, the effect of the setting aside of an international arbitral award by the Delhi High Court. It is vital discussion on the implication of annual awards, interplay between the jurisdiction and arbitral seat, and the challenges posed by the conflicting judicial interpretations. These topics chosen by Maadhyam are not only deeply relevant, but also profoundly impactful on the evolution of the arbitration law in India. Moreover, I am sure that it helped the audience, which comprises the young professionals and the students, to understand the complex legal principles and inculcate the same while practicing law. Arbitration law has always been viewed as an interesting and upcoming area of law. However, that is not true, and its development goes back to the ancient times and even before the British arrived here. To our shores, the means of arbitrations to remedy disputes had existed in the legal community, especially in India. It stands at the pivotal moment, especially with arbitration and ADR not being mere alternative to litigation anymore. Yet their success relies on our collective ability to interpret the apply the law, the clarity, consistency, and the foresight. The Honorable Supreme Court has made great strides in the regard, but the road to success has not been easy. It is also vital to understand the promulgation of the Arbitration Act 1996, which is a consolidation of procedures practicing to domestic and international arbitration. There are making it momentous event in the modern legal history in India. It is framed between of the modern law on international commercial arbitration. The Act came into being at a very crucial time of economic liberalization in India. It has been cost-effective and forward-thinking. Arbitration was the need of the hour, so that the nation could meet international requirements of economically viable and quick dispute resolution. At that time, the Act was also viewed as a contemporary subject matter where dispute resolution has become easier while not burdening the courts in the long-drawn and lethargic commercial disputes. Today, when we examine the concept of the judicial intervention in arbitration, we have come a long way in establishing a balance between judicial review and arbitral autonomy, especially when it comes to the distinction between sections 34(2)A and section 34(2)B of Act 1996. The Honorable Supreme Court has amply adjudicated on the said issue. There is no depth of the judgments that clearly distinguish the two and jurisdictional exercised by the arbitral tribunal. I am sure that the esteemed panel members have taken you through the provisions of section 34(2)B and section 34(2)B, and the distinction therein is a great detail. I would like to merely limit myself in discussing in three case laws of the apex code, which I believe has transcended the view on the subject matter. On the here perusal of the provisions, it can be said that the former provisions deals with the procedural aspects and the later deals with the substantive aspect of the law. Briefly stated, section 34(2)A states that the arbitral award may be set aside if the party is under some incapacity or the arbitration agreement is not valid under law, or the party making the application has not given a proper notice for the appointment of the arbitrator, or the arbitral award deals with a dispute which is not governed by the terms of the submissions or beyond the scope of submissions to the arbitration. Or lastly, if the composition of the arbitral tribunal or procedure were not in accordance with the agreement of parties, adhering to the provisions as well as the intent with which they were promulgated. However, the difficulty arises in interpreting the section 34(2)(b)(2), which was the main focus of the sessions. The words public policy has been interpreted in the varying manners by the Honorable Supreme Court, and this has no doubt caused uncertainty in its interpretation. The judgment, I feel, that provided the best calculation of the terms or interpretation of the terms public policy was the case of Renu Sagar Power Electric Company Limited versus General Electric Company, that is 1994 Supplementary 1 SSC 644. While examining whether the term B construed in a broader or narrower perspective, the Honorable Court chose the interpretation terms public policy narrowly in the context of private international law in light of the pro-enforcement bias envisioned by the New York Conventions. It held that the foreign arbitral award could not be refused enforcement just because it is in violation of Indian public policy, except when in violation of first, fundamental policy of Indian law, second, the interests of India, or third, justice or morality. In my opinion, this judgment showed balance, judicious nuance, and paid attention to its relevance to the current as well as the future times, thereby taking into account the international arena as well as the pro-arbitral attitude prevailing at the given time. However, a fresh interpretation was given to the term public policy in the infamous case of ONGC versus Swap Pipeline Limited 2003 5 SSC 705, which most of you are aware about. The issue before the Honorable Court was a defined public policy in the context of setting aside of the domestic arbitral award, moving to the other end of the spectrum from Renu Sagar. The apex court introduced the idea of patent illegality, which is in contravention to the provisions of the Act itself. The rationale behind the view taken by the Honorable Court was that since an arbitral award was created by the Act itself, any violation to the provisions of the Act would amount to the intervention of the courts. This new interpretation of patent legality to the section 34(2)(b)(2) widened the scope of public policy expansively. Saw Pipeline's case observed that patent illegality is something which examines the rules of the matter, which is so unfair and unreasonable that it shocks the conscience of the court, and observation of such did open the floodgates in the petitions under section 34(2), and in my opinion defeated the very purpose for which arbitration was created. Therefore, the said judicial interpretation and expansion of the ambit of section 34 as well as the judicial overreach continued with the numerous judgments such as ONGC versus Western International Limited 2014 9 SSC 216 and others of its, where a duplication of the provisions of section 34(2)(a) was included in 34(2)(b)(2). I will leave it to you all to read that judgment and see struck and strange replication of provisions and interpretation of Section 34, which Renu Sagar took a contrary view. The turning point in the interpretation of the public policy and the advent of the 2015 amendment came in the forms of the 246th Law Commission of India. I was in this report that the Law Commission heavily criticized the Shaw Pipeline's judgment. However, the true turning point came into picture only with the brilliant judgment. I will say the brilliant judgment. That is Sangwon Engineering and Construction Company Limited versus National Highways Authority of India, the 2019-15 SSC 131. That turned the tide and, in my view, corrected the wide interpretation of public policy. In Section 34(2)(b), relying on the 246th Law Commission report, the Apex Court observed that the law as laid down in the judgment, such as Western Geo International Limited, were contrary to the observation of Renu Sagar, and a conscious effort was taken in St. Leon to bring the interpretation of Section 34(2)(a) and Section 34(2)(b) back in conscience with the observation laid down in Renu Sagar. The judgment of Sanction was most definitely not only the correct approach, but also necessary to bring the Law Commission report as well as legislative intent back to the provisions of Section 34 and step out from the shadows of the judgments such as Shaw Pipelines and other similar judgments which in view area pure judicial overreach. Now coming to Section 34(4), which in my opinion stands at a very unique place in the landscape of arbitration in India and should not be conflicted with the other subsections and grounds set out in Section 34 for the setting aside of an arbitral award, while Section 34(2) is the only recourse for agreed party to challenge an award, especially if they can so bound the challenges into the limited grounds that are provided for. There is another opinion as well, which is often overlooked. The proceedings under Section 34(2) can be adjourned with the filing of an application under Section 34(4) by either party, and the arbitral tribunal is granted an opportunity to eliminate the grounds if it deems fit, based on which the arbitral award may be set aside. As both Sections 2 and 4 of Section 34 were part of the discussion today, it is important to understand the difference between Section 34(2) and Section 34(4). It is always ideal to delve into the provisions in the entirety and the grounds which it provides to challenge an award. I will not go into reiterating the provisions of Section 34(2), as I am sure that everyone here has a clear understanding of them. However, it would be remiss of me not to point out that the provisions of Section 34(2)(b) are substantive defects and go to the very root of the award. B, it is that dispute is not settleable through arbitration or that it stands in conflict with the public policy of India. I would be bold as to say that I do not believe that the legislative intent was ever to give the arbitral tribunal a second opportunity to review a matter which was contrary to the public policy of India, as Mr. Chandyol has given the opinion. To understand of Section 34(4), the Apex Court in the judgment of Dhyana Technologies Private Limited, that is 2019 SSC Online SSC 1656, had shed adequate light and let out a clear distinction in awards that have curable defects and those that do not. The Honorable Supreme Court again in 2022 in the matter of IPIC Clearing Services Private Limited, that is 2022 SSC Online, Supreme Court 4 laid down that section 34(4) may resorted to fill in gaps in the arbitrary award. It cannot, however, be implied if no findings are recorded therein at all. Maadhyam has also chosen one of the most nuanced concepts of arbitration to the part of this session, that is international awards and the impact of the setting aside the international arbitral award has on jurisdiction and the seat. Now there is a reason why I find this topic to be one of the most nuanced topics that has been chosen, and that is because of a relatively simple words, namely the seat. Red firm observed that the seat of arbitration is intended to be the very center of the graving of arbitration itself. And yet, it is also observed that dispute its importance, proceedings do not have to take place at the seat. I find that the word seat has evolved through so many interpretations through judgments of various courts that today is one of the most difficult and yet crucial concepts to understand for not just domestic arbitration but international commercial arbitration as well. I urge everyone here to pick up the judgment of Bharat Aluminium Company, that is Kaiser Aluminium Technical Services 2012 9 SSC 553, and go to it with a fine-tooth comb. Not only are the views the submissions of the best and most prolific lawyers in our country are recorded therein, but the judgment itself was authored by Justice S.S. Nijar, which is a master class in understanding the power of the Arbitration Act pertaining to international arbitration. The way of understand what is the impact of an Indian court setting aside the side of an international award would be to firstly understand whether Part 1 of 1996 Act is applicable to international arbitral award or not. It was observed in Balco that Part 1 of the Act only applies if the seat of the arbitration is in India. Balco was made it clear that the international commercial arbitration, if it is clear by the provisions of the arbitration agreement, provision that the legal judicial seat of the arbitration in India, then even if the venue fixed somewhere else, nonetheless the seat of the arbitration would still remain in India. I am sure my esteemed panel members have taken you all through the minute details involved in international arbitral awards. However, we must always bear in mind that just because proceedings are conducted domestically does not preclude the award being an international one. It is purely dependent on the law that will be used, and this can only be understood through the provisions stated in the arbitration agreement. However, it is clarified that Part 2 makes no provision for setting aside of an international award. That extent the powers enhanced the Part 2 pertains to only the commencement of the arbitration or the enforcement of an award. There are numerous judgments of high courts from across the country, not only that of the Delhi High Court, that has advocated on the question of setting aside of the international arbitral award. It appears that the findings regarding enforcement of the foreign awards by the Delhi High Court have for the most part stayed in line with the observations made in Bali. I would like to conclude by firstly appreciating and acknowledging the efforts put in by the members of the Maadhyam in making this event successful. I came to know about the educational discourse that took place between the esteemed and learned panel members and the students and young professionals present in the audience today. I once again thank the wonderful public people at Maadhyam for having me at this event, and to express my thoughts on each point's concept of the arbitration. I wish you all the very best. Thank you very much.
Thank you, my lord. What we could not do throughout the day, your lordship has done. Grateful to you, Lord. Thank you very much for spending time to us and be amongst us, giving us the necessary impetus to work more. We assure you in this path of journey to share knowledge with our youngsters or even colleagues or will not hesitate or they will continue. Sakshi was one of the recipients of the award. She is in Australia and she wants to share something with you. Sakshi, could you please come on?
Thank you, sir. Thank you for this opportunity. I just want to know if I'm audible and visible.
Yes, you are audible.
Sir, I've been, it is so serendipitous that I met Sadhna ma'am for the first time 8 years back when Maadhyam's inauguration ceremony was happening. And ever since then, she's an inspiration not just for me but for an entire generation of young professionals. And she used to say that mediation is a living cultural heritage. And that's how Maadhyam is carrying it forward. I also think that everybody in Maadhyam is so inspiring, and I'm so proud to be a founding member. And to all the young people sitting there, I want to say that they shouldn't miss this opportunity to be a part of a team like this and to be learning from the best. And it is incredible how the ADR series is coming along now, called Sadhna Ramchandran series. And again, they say that when you do something good from your right hand, your left hand should not know about it. And that is how Maadhyam does its work. And therefore, people don't know about the incredible philanthropic work that is being done by Maadhyam. And but I want to say it, and today I got a chance to contribute to that, to the Keval Memorial Fund and the amazing work. And again, I just want to urge everybody to be a part of this movement which will change the landscape of ADR in India and the world. Thank you, sir.
Well, I wanted to share with your lordship that Sakshi is a joint secretary in Maadhyam. She actually is responsible for the entire faculty. She looks after everything. She is actually on the part of academics and as lawyer. She's the one who does everything. Questions she frames. Everything is done by her. And on behalf of all participants, let me thank you, Sakshi, for continuing to do those things.
Absolutely my honor and privilege, sir. Thank you so much.
Let me thank all participants, which I see from across boards, not only in the High Court, but I have youngsters who have come from other courts this episode. We are only requesting you that once you go back, your responsibility starts then, that you must convey to your colleagues in the bar as to what we should do, because it's always a collective effort of the bar that will be able to achieve the point that we intend to make. I have no hesitation that with all your efforts, we will grow this movement. In 2006, as everybody knows, my lord knows about it, that we started mediation in a very small room. And it's a proud moment for Delhi High Court that we have 32 rooms, about 80 matters a day in the mediation center. And with so many mediators looking into it, co-mediators coming with us, And in Maadhyam, we have experts who have done wonders in arbitration. We have about 26 of them who have already cleared Singapore Mediation Center and have become mediators there. 6-7 of us are L4 mediators there. And consequently, this is how we intend to take the movement forward. At the time when India was signing the Singapore Convention, the government of Singapore invited Maadhyam to be part of the ceremony. And that's how, in a small way, we are contributing to this thing. With the encouragement that you got at your hands today, I'm sure we will carry out this mandate further. Let me thank Rinku, who heads the organizing committee, for arranging all this. And along with her, of course, is Pooja Jain, Mamta, and Pooja Anand. They form a team. No words to thank Sarika Rani, the secretary general. Untiring effort by her, all through. And I saw her yesterday how she was looking at each bit and looking at checkpoints to see what is to be done. Atul Batra, another joint secretary, has been contributing everything to us. We have Lord Neelam Rathore with us, the vice president. She's not well today, and so she's not amongst us. And another person who is giving us always encouragement, take us along, give us the view. And of course, we are all led by none else but Davison. Not only is the president-elect, but actually he is the president. I am just giving the dice with you, that's why I thought we'd give it to you. Thank you all, Jasbir ji, for you being the project in charge. Every arrangement made here is all done by Jasbir. So we must. If I left out any name, don't feel upset. I'm including everybody. So each one of you have contributed to my mind. Those who have come, those who have arranged, those who will come. So I would expect that the next episode when we announce, each one of you will carry at least 2 more members. The purpose is that we must reach out to people, tell them these are the difficulties in the interpretation that we're facing. And I always find in new, like the youngsters on my left, I'm sure when they read the statute again, they will say Supreme Court is also wrong, High Courts are also wrong. So innovative interpretations are required as the need is increasing, and I'm sure we'll be able to do that. We thank you all, and before we do anything else, I think the best is to call J.P. Singh, the head of our Maadhyam President, to please say a few words. I want to thank her.
Lord, I have always said that it's very difficult to step into his shoes. And this is the, we had given this title to our patron, Ranjan Bhai. He is the one who started the mediation movement. And he never liked this term. In Mahabharata. He said he was the most ineffective person because he couldn't do really what was required to be done. Then it was most required to be done. Thank you, my lord. I thank Justice C.D. Singh for taking out time from his busy schedule and addressing us on this topic with his words of wisdom. Thank you so much. I would like to thank our resource persons. I would like to name them: Professor Akash Gupta, Mr. Ashish Mohan, Professor Apurva Dikshit, Mr. Gaurav Bachanda, Senior Advocate, Professor Akansha Singh, Mr. H.S. Chandyo. Thank you so much for taking our time and taking us. One person who always praises you but never accepts praises for himself, that's Mr. H.S. Chandyo. He keeps us on our toes, by these thought-provoking topics as you've seen today. Of course, and he gives credit to Sakshi. And his tireless efforts, actually, and exuberance and foresight actually keeps this Maadhyam in the forefront. Thank you, sir. Thank you for leading us. I would like to thank the entire team. Of course, Neelam is not here, others you have already seen. Thank you, everyone, for making this happen. Thank you, India Habitat Center, for this wonderful place that we have today and the entire convenience, the lunch, the tea that we had, and of course, you will be joining us for tea again. Thank you all the participants, because you make it happen. But for you, we wouldn't be here. Thank you all of you for coming. Only one reminder I want to give it to you in our endeavor to preserve the environment. I know most of you, when you go back, these lanyards will be put somewhere else. So you may leave these lanyards at the reception so that we can use them the next time, when we do the next episode. Thank you, everyone. Thank you so much. Please join us.